Good morning, sir. Can you see and hear us?
Yes, thank you very much.
So our next witness is Tony Kearns.
Yeah.
Please could the witness be sworn?
Repeat after me. I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth.
Mr. Kearns, as you know, my name is Miss Hodge and I ask questions on behalf of the inquiry. Please give your full name.
Anthony Paul Kearns.
You should have in front of you a witness statement dated the 9th of May of this year. Have you got that there, please?
I have.
This is the second statement which you've provided to the inquiry, is that correct?
It is.
It runs to 15 pages. Could I ask you please to turn to page 14 of that statement? Do you see your signature there at the end of the statement?
It's actually not on this hard copy I've got.
If you could just bear with us, we'll ensure that you have a copy with your signature.
Yes.
Thank you. So you can see your signature there at the end of the statement dated 9th of May of this year. That's right.
Yes.
Thank you. Thank you. Is the content of that statement true to the best of your knowledge and belief?
It is.
Thank you. That statement will stand as your evidence to the inquiry in phases 5 and 6. I shall be asking you some questions that seek to expand upon and clarify some aspects of your evidence. You first appeared before the inquiry on the 29th of November 2022 when we were examining issues of relevance to phase 2. Is that correct?
Correct.
I don't intend to revisit those issues with you, save to the extent that they are relevant to the issues that we're examining in phases 5 and 6. Is that clear?
It is.
Thank you. Now, in terms of your roles and responsibilities, you were previously employed as an assistant secretary of the Communication Workers Union between 1997 and 2002. Is that right?
That's correct.
Whilst employed in that role, your primary responsibility was to promote the interests of CWU members who were employed by Post Office Limited. Is that right?
Correct.
This would have included Post Office counter clerks who were employed at Crown Office branches, staff working in cash centres, and administration staff working in the Post Office's back offices. Is that right?
Correct.
You say that since 2002 you've been employed as the Senior Deputy General Secretary of the Communication Workers Union. Is that right?
That's correct.
You were elected to perform that role by the members of the union, is that
yes.
right? In your statement, you say you've not had any direct responsibility for Post Office matters since your appointment as Senior Deputy General Secretary. Is that
That's correct.
Who within the senior leadership of the Communication Workers Union has had direct responsibility for postal matters since 2002?
Andy Fury.
Thank you. I'd like very briefly to revisit some of the evidence which you gave on the last occasion about your role as a member of the Horizon Working Group during 1999 to 2000. This was at a time when you were employed as Assistant Secretary with responsibility for Post Office employees. Is that right?
Yes.
The Horizon Working Group had been established to oversee the operational live trial and later the national rollout of the Horizon system to the Post Office network. Is that correct?
Correct.
You confirmed on the last occasion that you gave evidence to the inquiry that you were made aware of technical issues being raised during the live trial. Is that right?
Correct.
And you understood these to relate to balancing. Is that right?
I was informed by Crown Office staff on visits that I would make to local branches that some individuals were experiencing difficulties with balancing following the introduction of the Horizon project.
And just to confirm, by balancing, you mean that whether the money received in and paid out by the branch was accurately recorded in the weekly financial accounts. Is that right?
Each counter clerk employed at a Crown Office is responsible for their own individual balance. On a Wednesday, they ended the balancing week, and that's when that balance takes place.
I think you said on the last occasion that problems with balancing had been reported to you before Horizon was implemented. That's correct, is it not?
Yeah, we regularly had staff who reported difficulties with balancing prior to and subsequent to the introduction of Horizon.
But you said that after the introduction of Horizon, it was your perception at the time that the number of people reporting problems had increased.
Yes.
Is that right? And I think you've just confirmed that that was information you'd obtained during your visits to local branches.
Correct.
Were these problems with balancing an issue that you were recording or tracking at a national level within the Communication Workers Union at the time?
No, we had a process, which I think I outlined in my witness statement, for how losses and gains or incorrect balances were dealt with through a system losses and gains procedure that was in place at the time and subsequent to the Horizon project.
We'll come on shortly to that, but just dealing firstly with the issue of how the issue was being, let's say, monitored. I think your evidence is it wasn't at a national level. Is that fair? That is to say that you weren't keeping records or you weren't tracking the number of branches or the number of staff who were having difficulties with balancing? No,
there was no facility or process for that.
Would it be fair to say that you were relying on those local procedures to identify whether balancing problems were caused by the system or by the performance of the employee?
Yes, that would be dealt with through that losses and gains procedure at various levels.
Do you think that local representatives and branch managers would have had sufficient knowledge or understanding to identify whether a balancing problem was caused by the system or by the employee's performance?
I couldn't say whether they were able to identify specifically whether a misbalance, a loss or a gain, was directly attributable to the system.
If you were not tracking the issue at a national level, how would your local reps know whether they were dealing with an isolated incident or an issue affecting several branches or employees?
I think I made either in one of my statements or last time I gave evidence. So we have a network of representatives who operate at local branch level, sort of area level, a regional level, and then a national executive. And what would happen if somebody was... So there was a process in place, a losses and gains procedure. And what would happen is if somebody was considered by the post office to be fallen foul of that procedure, they would be called for interview. They would talk to their local rep or their area rep or their regional rep and ask for representation. So dealing with those, the idea of that system as the idea, all of the agreements and sort of the industrial relations framework we had with the post office at the time and still through to today, is to get these matters dealt with, for want of a better phrase, at the coalface, at the lowest common place you can deal with it. So people having local first-hand knowledge would be the office rep. Subsequent to that would be the area rep. So if someone found themselves in difficulty over the losses and gains procedure and was going to be called for interview, they would contact their local rep or their local union branch and they would deal with the issue. So those issues were dealt with predominantly by at a local level.
I understand the point you're making, but I think the gist of my point is this: if it's not being looked at a national level, would those local reps and those local branches, would they be able to know that this was something that was affecting more than one area, do you think?
Yeah, we would have regular meetings of local reps would meet regularly at branch level. Area reps, regional reps would get together and discuss the problems that they were facing, how best to deal with them.
So you would have expected that to have been discussed at the branch level, at the regional level, if it had been something that was causing significant difficulties.
If those reps had a wide-scale concern, yeah, I'd expect them to discuss it with each other. Standard practice in sort of sharing, I've got this problem, how have you dealt with that? I've got a new problem, how have you dealt with that? It's how reps sort of interact and build up their knowledge.
Now, when you finished in your role as Assistant Secretary, to whom did you hand over responsibility in 2002?
Andy Fury was elected, so it wasn't me handing over responsibility. He was elected by the membership.
Into the role of Assistant Secretary?
Into the role of that Assistant Secretary.
Did you brief him on the knowledge you'd obtained during your time as a member of the Horizon Working Group?
Andy Fury was an elected member of our National Executive prior to being elected to that position. And given that his background was he was directly employed by the Post Office as a counter clerk, Crown Office staff, he worked closely with me and would attend a lot of national negotiations. So in reality, there was no formal handover insofar as he'd worked in my department with me for the previous 5 years. So he was more than well aware and was involved in a lot of discussions about these matters up to that point.
So your evidence is you wouldn't have done a formal handover, is that right?
It's correct.
But you think you would have discussed issues, including issues with balancing, with him before he took over that role?
Myself and Andy worked almost together on a daily basis over a number of years, and anything I was aware of in my role, he was aware of.
I'd like to move on, please, to a new topic, another topic which concerns the support and the representation which was available to members of the Communications Workers Union if they were held accountable for shortfalls shown by Horizon. Now, you address this at paragraph 33 of your second witness statement, please, if that could be shown on the screen, WITN 06370-200 at page 7. Thank you. Page 33, paragraph 33, please. Thank you. This reads, the CWU has always provided strong and effective representation for members accused of accounting discrepancies. Just pausing there, please. Is that assertion based upon your personal experience of representing members of the CWU?
It is.
Are you referring here to cases where the accounting discrepancies were shown by Horizon?
I'm referring to cases that our members would be called for interview under the losses and gains procedure.
And is that, you said you're talking about your own personal experience, is that before Horizon was implemented or after Horizon, or both?
Both. The losses and gains procedure is what was used to, for want of a better phrase, measure the ability of counter clerks to do their job. I was a counter clerk before I was an elected representative, and the losses and gains procedure in various formats, been rewritten a number of times, is the measure that individual counter clerks are held to see whether or not they can do their job. Each individual counter clerk, as I explained earlier, balances their stock on a Wednesday evening. That will either balance or it will produce a loss or a gain, either of which in the eyes of the Post Office, losses and gains are considered to be evidence of an inability to do the job to varying degrees, and there can be a variety of reasons why people record losses and gains, and then there was a process to take people through to investigate why those losses and gains have occurred, mostly designed to be corrective.
Mr. Kearns, I wonder if I could please ask you if you can try to slow down in your answers, please, just to assist our stenographer who's making a record a verbatim record of what you're saying.
Apologies.
Thank you. Forgive me, coming back to the question, please. Is it your evidence that you have personal experience of representing members of the Communication Workers Union who were accused of accounting discrepancies after Horizon was rolled out?
Me personally, no.
No. Are you aware of any specific cases in which members were asked to account for shortfalls shown by Horizon?
No.
Now, you stated that your responsibilities relating to the Post Office ceased in 2002. from where have you obtained your knowledge of cases after that date?
I don't really have any detailed knowledge of cases after that date because it wasn't my responsibility, it wasn't my day job. I've paid a general interest to the union structures and how it represents its members since then, because that's my job to sort of oversee partly how the union functions. But I don't have any first-hand experience since I left that role in 2002 of individual cases.
So would it be right to say that as a general assertion that you're making there, it's not one based on any personal experience after 2002?
Apologies, general assertion.
So you're making a general assertion that the CWU has always provided strong and effective representation for members accused of accounting discrepancies. What I've been trying to explore to you is the basis of that assertion. And I think what you accept is that after 2002, you had no personal experience of those matters, and you don't have any information about any individual cases. Is that right?
I don't have any personal experience, and I never didn't deal with any individual cases. My assertion about the CW dealing with them is that the reps structures that we had in place to deal with those issues it's changed, but it remains broadly the same, as in we have local reps, branch reps, what used to be called regional reps are now called territorial reps, who deal with those issues on a day-to-day basis, and that procedure remains largely in place, as does a losses and gains procedure that they would work with.
Now, before we come to losses and gains procedure, do you know what type of training union representatives received to enable them to provide support to staff who have found themselves in this situation where they're being asked to account for discrepancies?
Yes, we would run what we would call schools, educational classes, every time, more or less every time a major agreement would change. We would get reps together at varying levels, explain to them the changes any changes we negotiated in policies and procedures, and train them through what we would call basic skills. We now call them skills 1, skills 2, on how to be an effective rep, how to engage with an individual who might be having problems, how to represent that to the employer. We had an education and training program designed to do just that.
Now, you go on to say at paragraph 33 that the CWU collective agreements, including the losses and gains procedure, have been significant in ensuring a fair hearing for directly employed members. You've referred to that procedure in your evidence before the inquiry on the last occasion. I think you recall it being in place at the time when you were Assistant Secretary, and you've said just now it's something which has been updated over the years. Is that correct?
That's correct. I was employed by the Post Office in 1978, and there was a losses and gains procedure in place then. And some of the papers sent to me show a losses and gains procedure from, I think it's 2013 and 2014, a losses and gains procedure for directly employed counter clerks, as we used to call them, by the Post Office, has been in place for that length of time.
Now, would it be a fair summary to say that policy applied a threshold, or a number of thresholds, below which an accounting discrepancy would be treated as a performance issue, but above which it might be treated as suspected theft? Is that a fair summary?
No, that's not how the losses and gains procedure was applied. The losses and gains procedure, if individuals fell foul of that procedure, they were given the opportunity to explain why they thought that. The Post Office would be saying to them, your performance is unacceptable, we need improvements. They'll be given deadlines or a number of specific occasions where they were allowed to misbalance before more serious disciplinary action would ensue. My experience is that mostly people would understand the seriousness of the situation, for want of a better phrase, apply themselves more diligently to their job, and were very unlikely to fall foul of that procedure to the point of dismissal.
I think if we put to one side what might be characterised as small discrepancies, in the order of £5 or £6, which would ordinarily be treated as a performance matter. Is that fair?
Yes.
And if we consider a more substantial discrepancy in the order of several £100 or possibly even several £1,000, a discrepancy of that type, would it not be referred to the post office to be investigated as suspected criminal activity?
My experience was single large losses like that would be dealt with outside of this process and would usually be subject to a specific investigation.
So if Horizon was showing a substantial shortfall, which a post office staff member could not explain, they would not be helped by this procedure, would they? That is to say that they would be in exactly the same position as a sub-postmaster who had a substantial shortfall which they couldn't explain, would they not?
If at the end of the week an individual counterclerk's balance at a pre or post Horizon showed up a significant amount of the amounts that you've referred to, my experience is that would be investigated by the post office investigation branch as it was then, or whatever its title is now.
And essentially you as the CWU and that staff member would be reliant upon the post office investigating the cause of the shortfall, would you not? And establishing whether any fault lay within the system.
Yeah, the post office they would interview the individual for their view of why such a loss occurred, and then the post office would make its own investigations.
Now, if we go back, please, to your statement at paragraph 33, you go on to say that the CWU has no record of any of our directly employed members losing their jobs or being prosecuted due to problems with Horizon. What I want to ask you is this: does the CWU make and retain records relating to the dismissal or the prosecution of its employees, of its members? Forgive me.
No.
If you don't have any record, or if you don't make and retain such records, does it not follow that there might well be directly employed members who have lost their jobs or been prosecuted due to problems with Horizon, of which you're not aware?
That's possible.
So would it not be more accurate to say that you don't know whether, and if so, how many of your members have lost their jobs or been prosecuted due to problems with Horizon, because this isn't something which you've actively monitored?
So the statements I make, which is the CWU has no record of any of our directly employed members losing their jobs or being prosecuted due to problems with Horizon, it is a statement of fact as far as I'm concerned. We don't have that record. Because of the extensive network we have of reps and the relationship we have between the national officials and our local reps and regional reps, my belief is that we would be made aware if individuals had come to our reps at local level and said to us, we're losing our jobs, or we're being, let's take the issue of prosecution. If any of our members were to be prosecuted over that, we're fairly certain that they would come to our reps through the process I've outlined. And if our reps thought that was a problem, they would come to us, but we don't have any record of that.
Now, I think what you've just said really is that you make an assumption that that information would have filtered its way up to national headquarters if that had been the case. Is that fair?
Yeah, we would assume our reps would tell us if they were being asked by our members to assist them in such cases.
You've also said earlier that you would have expected these issues, accounting discrepancies, to be resolved at a local level, and that you didn't expect that to be something that would be escalated to national level.
Are they two separate things?
In what sense?
So I work at a Crown office. I used to work at a Crown office, and I work alongside people who, on a Wednesday night, would do their balance and would misbalance more regularly than the losses and gains procedure at the time allowed for. So they would be interviewed by the post office with their union rep or their local area union rep, and they would go through the losses and gains process with the intention of rectifying their performance on the job, so to speak. They were regular occurrences when I was a local rep, I used to deal with those cases on behalf of members, 1 or 2 a month. They're just dealt with at local level, and that's where it ends. And that's the idea of that procedure, is to rectify those problems, for a better phrase, at the cold phase, so as the individual counter clerk can prove that they're doing their job properly. It's also true to say that if our members were being dismissed or prosecuted, and our reps felt that was, for a better phrase, unfair and wanted to defend them and wanted our assistance in helping them do that, they would come to us.
And are you saying that at that stage there would be some record held centrally of a request for assistance, or that effectively you would have some record showing that that request had been made?
Yeah, if somebody wanted us to help assist them in representing the member, they would email at that back to 99, write to us with details of the case, asking us to could we assist, or as it was possible to assist, depending on the nature of the individual case.
But any record of that would have been in emails at the time, which presumably you haven't gone back and checked over, have you?
So, we asked our research department what documents, and I think our research department and Andy Fiori's department, my successor in that previous role, have provided a number of documents to the inquiry over the last couple of years with regards to what information we have around Horizon. And we haven't come across, to my knowledge, we've not come across any correspondence, emails or letters of that type.
Now, the final thing you say in paragraph 33 is this. There have been cases of actual theft amongst CWU represented grades, but invariably when people are caught out, they are quick, thank you, to admit to theft. In these cases, the CWU is generally not involved, as people resign before being dismissed. Now, again, are you speaking here from your personal experience of dealing with cases of theft?
Yes.
On how many occasions were you called upon to deal with cases of theft by CWU staff members while you worked as the Assistant Secretary?
Not when I worked as the Assistant Secretary, but when I worked as a local rep. When I was a local rep back in Liverpool. When I worked as a local rep back in Liverpool, I dealt with, from memory, from 30 years ago, from memory, 3 cases of individuals accused of theft.
And was it your experience that members who were accused of theft by the post office always admitted their guilt?
Of the 3 cases I remember dealing with, 1 didn't, and we subsequently won that case in employment tribunal. The post office had no evidence. 1 individual, I think I made this in my earlier submission, 1 individual was accused of stealing £500, who denied it right up until the final interview, and then admitted it, and then resigned, and then was subsequently prosecuted.
Were you involved in any cases of alleged theft after Horizon was rolled out?
No.
And therefore, insofar as you make a general statement about cases of theft, is it right to say that wouldn't apply to the period after 2002, of which you didn't have any personal experience?
I have no experience after 2002. Sorry, maybe I'm misunderstanding the question.
Sorry, it was badly phrased, so that's my fault. I'm saying insofar as you make a general statement about cases of theft, it's right to say that applies prior to 2002, but not afterwards. Is that fair?
I wasn't dealing with them after 2002, but generally, that's why I say in my statement, generally, is the CJO generally is not involved. As my experience is, if people are guilty, then they resign rather than wait to be dismissed. I've seen that prior to 2002.
Thank you. Now, when you previously gave evidence, you said that you were aware of the Post Office practice of prosecuting staff members, and you've just referred now to an instance of that. You also stated that prior to Horizon, I think you'd represented a member of the CWU who'd gone on to be prosecuted by the Post Office. In which type of hearings would you be representing individuals at that stage?
So the individual concerned showed a £500 loss in their weekly balance. They were then called to interview by the Post Office Investigation Branch, and they're allowed to have a friend witnessing, and the Post Office Investigation Branch puts it to them that a loss of that figure, around 500, couldn't possibly be a discrepancy. It was theft, and the individual denied it, and we went through the process of them being dismissed, me doing the appeal, and it was at the appeal stage that the individual changed their position and said that, in fact, they did steal the money. So, yeah, that's how that process is dealt with. So under the investigation process, the individual is allowed to have a witness, friend, whatever you want to call it, in the room with them, predominantly to make sure that that interview is conducted correctly, fair play, in line with rules. Yeah, and so I've dealt with that case.
So you would have dealt with it, and others in your position would have dealt with it at the stage of the internal disciplinary hearing, is that
Yes.
right? And any appeal hearing,
Yes.
which followed. Did the CWU offer legal representation to members against whom criminal proceedings were brought by the Post Office?
CW does not offer legal assistance to members for criminal cases.
And that's in any circumstances?
To best of my knowledge and experience, yes.
You've been shown some statistics relating to the number of prosecutions brought against sub-postmasters, assistants, and Post Office employees in the decade before and in the decade after Horizon was introduced. Is that right?
Correct.
Now, it's right to acknowledge that the records on which these statistics are based are incomplete, particularly insofar as they relate to the decade before Horizon was implemented. But I think you accept, do you not, that on the basis of the data we do have, it tends to show a substantial increase in the number of prosecutions brought against Post Office employees after Horizon was rolled out. Is that fair?
They appear to double 2002 over 2001, 2003 over 2001, drop back down again 2004. So they fluctuate, but it's certainly true to say in 1990. So assuming we're all reading off the same thing, it says in 1999 for employees, which is the people we were responsible for, there were 5. In 2001 there were 6. And then in 2002, there were 13. In 2003, there were 13. 2004, that dropped back down to 7. Then up to 11, then down to 6. So it fluctuates. But it is correct to say that in 2002, 2003, there were more than there were in 2001 and 1999.
Now, in your most recent statement, you say that you were not aware at the time of the rise in prosecutions and convictions of Post Office employees. Is that right?
That's correct.
Do you think you should have been aware, or that you should have known about this in your role as Assistant Secretary and subsequently as Senior Deputy General Secretary of the Union?
No, because as I said earlier, they wouldn't get reported to us. At national level, sorry.
But I think you said the opposite. I think you said you would have expected, had members been prosecuted, you would have expected that to have reached you at national level because you would have been told that.
No, I would expect it if our local reps thought that they should have been involved, they thought something wasn't right, I would have expected them to have raised it with us at national level.
So your
So I
expectation...
referred earlier to, they would email us or they would write to us saying, we've got a problem here, can you assist? And so I say we have no record of that. So that's why we wouldn't have been aware of, 1999, 5 prosecutions, if I'm reading this correctly, 2001, 6 prosecutions, if I'm reading it correctly. We would only be aware, or we would have been made aware, if representatives who had been dealing with those cases had contacted us basically to say, I've been dealing with this case, it looks like they're going to dismiss them, it looks like they're going to prosecute them, we don't think that's fair, we don't think that's right, is there something we can do, can we talk about this, so on and so forth. I have no recollection of people coming to me in my role as the Assistant Secretary at national level on raising that type of complaint, if you like, or concern.
What you seem to be saying essentially is that you were relying upon your local rep to effectively to identify if there was a system fault, were you not?
That is the system we have in place. As I explained earlier, the idea of dealing with discrepancies, or even not just discrepancies in balancing, if you like, on the counter, but any discipline cases for any reason, insubordination, failure to attend for duty. The whole system was set up to deal with those issues quickly at the point that they occurred. And then there would be a process you would go through where, in more serious cases, they would be escalated up in terms of the post office, their managerial structure, and in the case of the union, our representative structure. And that's how the issues would be dealt with. So, insofar as we would have no record of, let's say in 1999, exactly how many individual members of the CWU were interviewed under the losses and gains procedure, we wouldn't have that record because they were dealt with locally. So in the same way, if somebody was prosecuted, unless those individuals contacted us, unless representatives contacted us, we would have no record of that.
Okay, so unless either the member themselves or the local rep came to you and said, I'm being prosecuted because of a shortfall in Horizon, which isn't my fault, it's the system at fault, you're saying that there would be no record and you would have no awareness of the fact of prosecutions being brought?
We would have no awareness at national level, no.
Now, given what you knew about problems with balancing during the rollout of Horizon, do you think that the bringing of prosecutions by the Post Office is something which you ought to have been monitoring at a national level?
We weren't aware of the prosecutions at national level, so we wouldn't have been monitoring it.
Well, but my point is you knew that the Post Office brought prosecutions. Is that not something which you should have proactively been monitoring?
We were... So let me just step back on we were aware of the Post Office bringing prosecutions. At national level, we don't have a record. We don't keep a record of the prosecutions that the Post Office carries out. I think it's the point I made in my statement is usually historically by the time it got to that point, we'd have individuals resigning, so we wouldn't have a record of the prosecutions that the Post Office took out against direct employees.
I understand what you're saying, which is you didn't have one. My question was, do you think you should have had one, bearing in mind that you knew that there were increased numbers of Post Office staff who were complaining about problems with balancing?
No, because they were dealt with under the balancing procedure.
I'd like to move on to another topic, please, which concerns the CWU's representation of sub-postmasters. When you worked as an assistant secretary, the CWU did not represent the interests of sub-postmasters, is that right?
No, that's correct.
Do you know why it was that sub-postmasters were not admitted as members of the CWU at that stage?
Because they were members of the National Federation of Subpostmasters. And that was... So within the Post Office at the time, there were a number of different unions. There was the Post Office Engineering Union, who were responsible for lighting, heating, vans. There was the Communication Workers Union, who were responsible for directly employed Post Office staff working on Post Office, what now Royal Mail issues as well. There was the Communication Managers Association, who were responsible for representing managers. And there was the National Federation of Subpostmasters, who were responsible for representing subpostmasters. And so if you fell into one of those categories, the recognition of the employer for anybody employed in those categories were in those unions. So the reason we didn't represent them is because we didn't have recognition agreements and they joined the National Federation of Subpostmasters.
In your statement, you say that you don't consider the interests of sub-postmasters and post office employees necessarily to be aligned. Is that right?
I do say that, yeah.
What do you mean by that?
Well, because postmasters, so Crown Office staff, post office staff, were directly employed employees of the post office. Postmasters, to my knowledge and recollection, worked on a contractual basis as private business people, for want of a better phrase, and had a private contract with the post office. So there were two different groups. One were directly employed workers, the other were privately employed, private businesses, and directly engaged, if you like, as agents by the post office. So two separate interests. So we would negotiate and argue, for example, for increased wages and terms and conditions for directly employed staff, whereas my understanding at the time is the contract between the post office and sub-postmasters would remunerate sub-postmasters based on the transactions they did, which are two distinctly different things. They're not aligned.
Now, there came a time when the CWU started to recruit sub-postmasters as members of the union. Do you recall when efforts were first made to recruit sub-postmasters?
Only from evidence that's been given to me in this, and from my involvement on the National Executive Council from the union. I think that was around 2014, 2015.
Now, you've been shown a printout from the CWU website, which tends to indicate that the union were actively recruiting sub-postmasters in October 2011. That's NFSP 00001463, please. Thank you very much. If you look at the very bottom of the, thank you. If you look at the very bottom of the page, please. I think you can see this is from where it's drawn, so www.cwu.org/postmasters, and the date's the 3rd of October 2011.
Yep.
If we could just scroll down, please. Thank you. So in that first box, it identifies the chairman of what was called the CWU Postmasters and Agents section, and that's Mr. Nippy Singh. And a little further down, please. Thank you. There's a further box which identifies Mark Baker as the vice chairman of the same section. So it appears that by this time in October 2011, the CWU had established a separate section to represent the interests of postmasters and agents. Do you think that's a fair inference from what we can see here? Do you recall the circumstances in which these two individuals, Mr. Baker and Mr. Singh, joined the Communication Workers Union?
No, I wasn't involved in that. But from discussions, I was on. So the final decision on allowing them or setting up a sub-postmaster section and actively trying to recruit them was a decision of the National Executive Council, of which I was a member. And my understanding from memory, although I'm talking about 9-10 years ago now, is that they had a sort of dissatisfaction with the National Federation of Sub-Postmasters. They had a dissatisfaction with the direction the post office was going in a general sense. And my understanding was they didn't have much faith in the National Federation of Subpostmasters representing them, which is why they approached us. And then we went, well, if you're going to approach us and we're going to set up a section, we're going to try to recruit more people from that cohort into the union.
Now, in your statement, you say that one of the roles of the union is to regulate tension between its members. Is that right?
Between its members and the employer.
Between members and employer, but between but internally between members as well. Is that not right?
Do I say that in my statement?
If we go please to page 3, paragraph 8b. Thank you. So in the preceding paragraph, you describe the objectives of the union, and you go on to say here at B, they are to regulate the tensions between members and their employers and between members.
Yeah.
Do you consider that tensions existed or exist between the interests of sub-postmasters and post office employees, bearing in mind what you've said about their interests not necessarily being aligned?
No, I don't. No, I don't think there's a tension. We can represent and do represent separate groups of workers to the employers who not necessarily in the same workplace, not necessarily in the same, if you like, industry. So no, I don't believe that. No.
Thank you. Another related topic, please, which concerns the relationship between the Communication Workers Union and the National Federation of Sub-Postmasters. In your statement, you say at the time when you worked as Assistant Secretary, the two organisations held equal status. Is that fair?
They were both recognised by the employer, by the post office, as having negotiating rights. So yeah, equal status insofar as they could both directly represent to the post office the concerns of their members.
And you said you would occasionally communicate on key issues and priorities, but you did not collaborate on projects or member representation. Is that right?
That's correct.
Now, there came a time when the Federation and the union discussed a possible merger. Do you recall that?
I don't.
It may assist you, please, if we could...
Sorry. Generally, yes. I think we were approached by the then General Secretary. I think at the time was George Thompson. But that wasn't my day job, so that approach would have been through Andy Fiori and the then General Secretary, I think, Billy Hayes. So only in the sense that we were also approached once by the Society of Telecom Executives, which was the managers in BT, where we also have members. And over the years, we do have general discussions with other unions and representative bodies about whether or not there is common ground, or there's the possibility of us merging, or are there any common interests. So yeah, that approach, or whether they approached us or we approached them, I don't know, because I was not involved. I'm aware that a discussion took place.
Thank you. Could we please bring up CWU 00000076? Thank you. As you can see, this is a report to the National Executive Council on the 18th of June 2015 for consideration at a meeting scheduled for the 25th of June. Were you a member of the NEC at this time?
Correct. I was.
Did you receive a copy of this report?
I would have done.
And you would have read it, presumably, at the time?
Yes.
Now, to place this in context, can we please take a look at the heading and introduction? So this report relates to the NFSP, Post Office Limited and CWU. Under introduction it reads, "It is prudent for us to consider the challenges, opportunities and options for the CWU given the likelihood that the NFSP special conference next month decides not to enter into a memorandum of understanding with the Post Office in preference to a transfer of engagements to us or the National Federation of Retail News Agents." This is a reference, is it not, to what later became known as the Grant Framework Agreement, that was concluded between the NFSP and the Post Office in July of that year. Are you aware of
I'm not aware of that last point. As I said, my understanding was, along with other unions over a period of time, the NFSP had approached us, as well as others, including the National Federation of Retail News Agents here, to understand or identify what scope there was for the two organisations to come together. But I wasn't aware of that other point, as I say, because that was no longer my area of responsibility.
What this appears to suggest is that approach you say you received from the NFSP seems to have come at a time when they were also in negotiations with the Post Office over a possible long-term partnership and a funding arrangement. Is that fair?
Yeah, I think that's fair. I referenced discussions we'd had with other unions about potentially merging with the CWU, but what happens is, if an organisation thinks there's a need to merge, for want of a better phrase, they'll keep a number of options open. They'll have discussions with a number of partners, if you like, and then come to a decision about which they think is the best fit for them. So yeah, they were talking to us, talking to the National Federation of Retail News Agents, and discussing with the Post Office, as I understand it, a new arrangement, which led to the contract that you just referred to.
Now, it appears that it was the expectation of the CWU that the NFSP would not enter into that agreement. Do you know why that was their expectation at the time?
No, my sense for that, having been involved in discussions with other unions over a period of time, is you get a feel whether you're just there, for whatever a better phrase, as a bargaining chip for them to go somewhere else. So they will say to whoever their preferred partner is, well, these are offering us a better deal. We're in discussions with this other group as well. So the deal better be really good from you, whoever you are, because we've got other options. Once you go through the sort of negotiation process on that, which I've been involved in but not with the Federation, you start to get a feel about whether they're serious about merging with you, or actually they're keeping their options open in case what they really want falls apart, and then they've got you as a backup.
Now, if we could move on, please, to page 3, and we see this issue addressed in some more detail. Thank you, under the heading Relationship Issues. Firstly, with Pol is the first issue dealt with. That reads, there was an exchange of correspondence with Pol in October 2014. This followed receipt by us of legal advice on the nature of Pol's relationship with the NFSP following the removal of the Federation from the list of accredited trade unions. Just pausing there, do you know why it was that the NFSP had been removed from the list of accredited trade unions?
I don't know the specific reason that would have been given by the CO, no.
If we go on, please, to the second paragraph, it reads, we need to return to that correspondence in the event of the merger process being terminated. So that's presumably a reference to the possible merger between the CWU and the NFSP. I'm assuming that's what that refers to. The exclusivity accorded to the NFSP does not appear to be consistent with particular legal obligations, especially as it necessarily means that CWU represented postmasters are excluded from arrangements which determine their contractual undertakings. Do you consider that the CWU was hampered in its ability effectively to represent the interests of sub-postmasters by reason of the fact that they were not formally recognised by the Post Office for collective bargaining purposes?
Yeah, I think so. In reaching out to anybody who wants to be a member of any union or the CWU is to say to them, this is what we can do on your behalf. So we can say to directly employed staff, what we can do on your behalf is go direct to the employer on pay, terms, conditions that directly affect you. We are recognised by the employer to bargain on your behalf. I believe, my understanding is as of today, we still don't have a recognition agreement with the Post Office for our Subpostmasters section. And therefore, the offer that you make to potential members one of the first questions they would ask is, what can you do on our behalf? And we have to say to them, we're not recognised by the post office to directly represent your interests. So in answer, not being recognised by the post office to directly represent their interests is a hindrance to recruitment of that cohort. In my view, sorry.
Well, it may be a hindrance to recruitment. Is it also a hindrance to effective representation?
Insofar as you cannot directly go to the post office, yes, it is.
Do you know the reasons which were given by the post office for refusing to recognise the CWU
No,
as representative?
I don't.
What, if any, steps has the union taken to address this?
I don't know. I think I've said in my statements since 2002, not my day job, Andy Fiore would be in the front line of making that representation to the post office.
Now, in the second half of this page, we can see the heading relationship issues with the NFSP as reconstituted under an MOU. It reads, we've received a copy of the much discussed proposed Memorandum of Understanding between Post Office Limited and the NFSP. This is attached. The most salient points of this document can be summarised as follows. We'll look at some of them now, please. The first one, summarising paragraph 2 of the draft MOU, the NFSP will reconstitute itself as a trade association or similar organisation. Are you able to explain, please, the distinction between a trade union and a trade association? What the significance of that would be?
Well, I understand what I know and believe a trade union to be on what its purpose is. And a trade association or similar organisation is there to protect the interests, as I understand it, of the business or the business owners, as opposed to all the workers who work in any particular trade or business. Which is why I suspect the certification officer no longer includes the National Federation of Subpostmasters as an accredited trade union, because the trade union certification officer has a strict set of criteria about what a trade union is, and them not being listed as a trade union means that they fall outside of that remit. So there is a fundamental difference in protecting a business or protecting a trade than there is protecting directly employed workers.
The second bullet point, please, states that under the MOU, the Post Office, not Post Office Limited, will provide funding of up to 1.5 million per annum from 2015-2016. It goes on to explain that the actual amount would depend on the difference between the revenues derived from the current membership model and the income stream and what they actually received. But it goes on to state at the bottom, in discussions, CWU representatives have described adoption of the MOU as meaning an inevitable cessation of subscription income, and no one, perhaps you read from rather than form, the NFSP has disagreed. So essentially a proposal to provide funding of up to £1.5 million. If we could go over the page, please. The second bullet point there reads, PO will provide additional funding of no less than £1 million per annum as a budget for grants to the NFSP. Thus, the gross annual value of the MOU is up to £2.5 million per annum. Was a funding arrangement of this nature usual for a trade union or trade organisation, to your knowledge?
It's not usual for the trade union. Absolutely not. Trade unions are almost predominantly funded by subscription income paid by their members. This document shows that position for the Federation was to cease, and they were to be funded directly by a payment from the employer or the post office.
Now, the document goes on to suggest that there were likely to be some conditions attached to the grant of this funding. If we can scroll down, please. Thank you. So these are referenced as part of paragraph 6. The first bullet point identifies paragraph 6 as a review mechanism for the agreement, and states at para 6C it says that the NFSP is not engaged in activities which are actively detrimental to the post office, but does not define what these are. The paragraph goes on to state that the post office acknowledges that the NFSP must have freedom to undertake activities that protect and represent their members' views. But in undertaking these activities, the NFSP agree that it will not introduce commercial risk to the post office. The author observes this is a very wide potential prohibition, and while the post office remains publicly owned, the proposed TTIP treaty, do you know what that is a reference to? The TTIP treaty?
I think that was an international. I think there was an international agreement around how businesses transact, standards that they had to operate under, from memory.
That could be prayed in aid as the arbiter of commercial risk were the treaty to be ratified, it suggests. It goes on to say that there are dispute management procedures which are reasonably transparent and have a degree of independence. But in the final bullet point, please, paragraph 6, final subparagraph says, should the NFSP disclose post office information that is confidential or commercially sensitive, as defined in the confidentiality agreement, or encouragement, and presumably was intended to read encourage, sub-postmasters to take action which conflicts with their contractual obligations, except where all other avenues of dispute resolution have been exhausted, these will be deemed a material breach of this agreement. Essentially the NEC being notified there that there's a new arrangement for funding to be made, but that funding will come with certain conditions. Is that fair?
That's my understanding of.
Now, if we could turn to the following page, please, we can see the overall conclusion reached. Thank you, by the CWU. Forgive me if you just scroll up a little bit. Thank you. So as to the effect of these provisions, the report provided there can be no doubt that the MOU represents the abandonment by the Federation of any meaningful independence. Our relationship with them and the employer would necessarily change as a consequence, as the CWU would be the only organisation of standing able to offer postmasters effective representation. Now, reading that, it rather suggests that the CWU believed at that time that the NFSP had compromised or was going to compromise its independence in reaching this agreement. Is that fair?
That's fair.
And that the CWU believed that it was the only organisation which could offer effective representation to sub-postmasters.
That was our view, yes.
Now, it's a related issue, but I'd like to deal now, please, with how the CWU responded to the emerging scandal. If we could please bring up your witness statement at page 10. That's WITN 06370-200. Thank you. At page 10, please. Thank you. Paragraph 43. You say this. I did not take any steps between 2009 and 2019 inclusive in raising any concerns regarding the integrity of the Horizon IT system with Post Office Limited, the government, the shareholder executive, UKGI, MPs and peers or journalists, as this issue no longer formed part of my remit to do so. Now, just pausing there for a minute, you've just told us that as a member of the NEC, you received a report saying that the NFSP had compromised or was compromising its independence. Is that correct?
That's correct.
Do you not think that you, as the Senior Deputy General Secretary, and other members of the NEC had a duty to take forward these issues on behalf of sub-postmasters who were not being effectively represented, in your view, by their trade association?
So the question was, did I take any steps? The answer is I didn't, because it was not my job to do so. CW structure at national level is we have a National Executive Council, which I sit on, which is responsible for finance, admin functions, things like whether or not we agree to merge with another union to form a union. Industrial issues, day-to-day industrial issues, which the post office and counter clerks are dealt with by a separate executive called the Postal Executive, of which Andy Fury is a national officer. I used to be a national officer of the Postal Executive from 1997 to 2002. And so those issues are dealt with not by the National Executive Council, but are dealt with by the Industrial Executive that I don't sit on and is not part of my responsibilities. So my statement was in response to the specific question that I was asked by the inquiry team. Did I take any steps between 2009 and 2019 in raising any concerns on that issue with those? And the answer is no, because as I've just explained, the remit for those was the then Assistant Secretary, current Assistant Secretary Andy Fury, and the Postal Executive.
Now, the role of Assistant Secretary was not as senior as a Deputy General Secretary, was it? In terms of hierarchy within...
In terms of the internal hierarchy of the union, correct.
Do you not think that this was an issue which required the involvement of more senior leadership?
No, because that isn't the structure. So the responsibilities of the national officials are laid out within the rule book. Mine is to assist the General Secretary, and the Postal Assistant Secretaries and the Postal Executive have sole authority over the industrial issues with the employers, Royal Mail, Post Office, etc.
Thank you, sir. I think the stenographer would like a short break, please. I have very few further questions for this witness, but I think there may be a couple of questions from the recognised legal representatives.
Yeah, that's fine. We'll take a break till 12:10.
Thank you. Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you, sir. Mr. Kearns, you've said in your statement and in your evidence that you simply weren't aware that sub-postmasters and post office employees were being prosecuted in reliance on data shown by Horizon. Is that right? At least for a substantial period of the time with which we're concerned.
Apart from when it became public, yes.
Yeah. Do you recall when you did first become aware?
I don't recall, no.
I wonder, please, if we could look again at that report to the NEC dated the 18th of June 2015. That's CWU 6076. This is the report we were looking at just shortly before the break. Insofar as it related to the changes to the constitution of the National Federation of Sub-Postmasters and its funding arrangement with the Post Office. It also contained an update on Horizon. We can see that, please, on the first page under the heading Horizon. It said this, as reported in LTB 26915. Is that a reference to letter to branch, LTB?
LTB, letter to branches.
Issued on the 21st of April, concern about the approach adopted by Post Office Limited to the alleged problems caused to postmasters by the Horizon operating system has now been raised directly with the Prime Minister. There has been a pause in political activity on this during the general election period, but Pol's lack of engagement with the mediation process, the attempt to suppress a report by Second Sight, the company engaged to investigate alleged shortcomings of Horizon, and continuing concerns of both CWU and NFSP postmasters mean that the issue will not subside. Now, it goes on to read, please, over the page. The Justice for Sub-Postmasters Alliance organisation has been set up by mostly ex-postmasters who believe that they've been unfairly treated. However, the key individual in JFSA, Alan Bates, is not currently in contact with the CWU Postmasters branch. This suggests, at least that at this stage, Mr. Bates hadn't approached the CWU directly for support for his campaign. Is that correct?
Yes, that's what it says.
On the face of,
that's
of what we have before us. And the second paragraph goes on to read, Post Office Limited position has essentially been based on the principle that the Horizon system cannot go wrong. However, this is not what we, NFSP and JFSA, are saying. Our position is that however robust a computer system there can be, and however robust a computer system there can be and have been problems. What this appears to be is an acknowledgement by the CWU that there have been problems with the Horizon system. Is that fair?
That's what that suggests, yes.
Now, the final paragraph reads, due to the collapse of the mediation scheme, at least 2 of our members will almost certainly now have normal Post Office disciplinary action taken against them because they are still serving, which will quickly culminate in Post Office Limited terminating the contract of one member and forcibly making the other pay back his losses by deduction to pay. Now, if we just step back for a minute, this is obviously in a report to you as a member of the NEC, that's correct, bringing to your attention concerns about Horizon, is that fair?
Yes, it references...
Concerns which the CWU shared at that stage, or by that stage. These were concerns that affected both former sub-postmasters and current sub-postmasters, some of whom were members of the CWU at that time, isn't that right?
Yes, I mean, well, we had a sub-postmasters section, so yes.
Given what you were being told in a report such as this, should you have done more, do you think, to raise awareness within government and to lend your support to the campaign to expose the failings of Horizon?
as I said before the break, that was not my responsibility. Our rulebook, which is under which the CW operates, that responsibility is the responsibility of the postal executive and the officers of the postal executive, in this case Andy Fiore, to deal with.
Would it be fair, do you think, to say that in essence the CWU left the group litigants to bear the burden of challenging the integrity of Horizon?
Given that I had no involvement with that issue at that time, I couldn't say I could agree with that statement. I'm not in a position to agree with that statement because I don't know what the executive and the officer concerned were doing on a daily basis on this issue.
Thank you. So I have no further questions for this witness. Before the recognised legal representatives ask their questions, is there anything you wish to ask, sir?
No, thank you, no.
Forgive me, sir, if we just pause for 1 minute.
Yeah.
Sorry, sir, we've had a late request for a further document to be put to the witness. It may be that the way we can approach it is to let Mr. Stein, if you have questions, to go first. I think the other representative is Ms. Watt.
Yeah.
We can review the position in relation to that document to ensure that the witness is given a fair opportunity to review it before he's asked any questions.
Sorry, we're going to hear from Mr. Steen and then Ms. Watt, and then review whether we need to ask any more questions. Is that it?
So, yes, I mean, my proposal is that we proceed with questions now whilst we review in the background what the effect of this document is, and then we will perhaps see where we are in the next 15 minutes.
Yeah, that's fine.
Thank you.
So no objection, of course, to that, to us proceeding that way. The difficulty, though, is that if the document is released and I need to see it and consider it for the purposes of any further questions, then I may beg an indulgence, which is to return to any questions that we may have arising out of that document. But on that basis, would you mind if I then go ahead with our questions for Mr. Kearns?
No, carry on.
I'm very grateful. Mr. Kearns, you're a long-standing employee of the CWU, the Communication Workers Union. You're employed in an elected position as the Senior Deputy General Secretary of the CWU. Is that correct?
That's correct.
You may or may not know, my name is Sam Steen. I represent a large number of sub-postmasters, mistresses, and employees working in branch offices of the Post Office. I've just got a couple of questions, using first of all your experience, if I may, as part of the trade union movement. In the judgment, judgment number 3 in the High Court, I'm not sure you have this, but I'll read out the relevant part. Judgment by Mr. Justice Fraser, now Lord Justice Fraser. He said this at paragraph 1120 of judgment number 3, that the National Federation of Sub-Postmasters is not independent of the Post Office. He went on to say, the Post Office also has a highly detailed funding agreement with the NFSP that would entitle the Post Office to claw back funds already paid to the NFSP if it does anything that would damage the Post Office's reputation, including supporting the sub-postmasters in this litigation. So he's making the points, which is the NFSP is not independent of the Post Office. There's a funding agreement with the NFSP allowing the Post Office to claw back funds paid to the NFSP if the NFSP did anything that would damage the Post Office's reputation. Help us understand, with your own work within the trade union movement, is that a normal arrangement with a representative body working on behalf of, in this case, sub-postmaster?
No, I wasn't aware of that specific, but having listened to what you said, I've never come across a representative body, trade union, that has such clauses in it. That doesn't sit comfortably with me as a trade unionist, that you could enter into that and claim to be a representative body.
And it may be in some ways obvious, but what's the problem with entering into an agreement to not criticise the employer of the people you represent? What's the difficulty?
Well, you take away your independence, you take away your ability to challenge the direction that the employer or the company is going in, because you think it's detrimental to both the members you represent. In the case of ourselves as the CWU, recent examples of Royal Mail, the service they're providing to the customer, to the public. If you're unable to challenge that, strikes me that it's more like a business partnership than it is a representative body for the individuals that make up the organisation.
Can I then ally that to a question that was asked by Ms Hodge that concerned and touched on collective bargaining? Now, you referred to collective bargaining at paragraph 7 of your statement, where you say that you must add that the CWU has long called for union recognition for collective bargaining purposes for sub-postmasters, but Pol has consistently refused to grant this. You've added in your evidence that you believe that's still the position today. Is that correct?
That's my understanding of it.
Now, paragraph 11 says this: we engage in collective bargaining processes with several employers on issues such as pay, terms and conditions of employment. So Ms Hodge was seeking to establish with you what if you like, are the advantages of collective bargaining on behalf of members of the CWU. You refer to it there as being discussions with employers on issues such as pay, terms and conditions of employment. What would be the effect of having what I'm going to call a shackle on a representative body to not criticise the employer in relation to collective bargaining?
My view is that the shackle would be that you're not able to effectively represent the members of that organisation, because, well, if you're restricted, for one of better raising criticism, so it's, I'll give an example. We had a major industrial dispute with Royal Mail some years ago. I understand that not everybody likes this, but we took major industrial action, which disrupted the service, partly because we didn't think our members were being treated with due respect, partly because the reason for that was because the direction that Royal Mail was setting out as a business, and therefore the industrial action that we eventually took was, if you like, for one of a better phrase, a protest against that, to defend our members against job losses, so on and so forth. If you're restricted from being able to make that criticism, then, well, you're not able to effectively represent those individuals who make up that organisation, is how I would see it.
Now, you mentioned to Ms Hodge the position of Mr Fury. Mr Fury, if I've got it right, is the secretary to the CWU, but also is the CWU's national officer for postmasters, CWU members who are working in post office branches and working in the wider post office. Is that correct? That's
correct.
Right. So that's Mr Fury's title is essentially to have to deal with all such matters in relation to CWU membership, sub-postmasters, people employed in branches and working within the post office itself. Is that right?
Correct. His title is the Assistant Secretary, Clerical, Cash Handling. So all those issues, which includes Crown Post Office staff and administrative staff.
Which is why in your evidence you've made it clear that since I think it's around 2002, that's not been your direct area of responsibility, it's been Mr Fury's. Is that correct?
March 2002, to be specific.
I'm grateful. And then turning to Mr Fury, are you aware that he's given evidence before select committees in relation to the CWU sub-postmaster branch employee membership?
I am.
Given evidence at least on 2 occasions that I can find on a quick search, is that right? And been interviewed generally as regards the post office and actions in relation taken by the management of the post office, and is quoted often in the press?
Yes.
And fairly obviously, Mr Fury would be someone that could be able to take any other matters further if there was any other questions to be asked by the inquiry.
Correct.
Thank you, Mr Kearns.
Ms Ward?
Good afternoon. Can you hear and see me? Thank you, Mr.
Yes.
Kearns. I'm just diagonally behind Mr. Steen there. Yes, we have this problem every time I speak. Thank you. I have some questions for you on behalf of the National Federation of Subpostmasters, and I think we actually spoke before when you were here the last time. Your union would have had hundreds, perhaps if not thousands, of members working in what was then hundreds of Crown Office branches using Horizon during the 2000s when the scandal was emerging. That's correct, isn't it?
Yes, my recollection, for around 2000, I think we have maybe 9,500 members. That's severely diminished through the 2000s and to today.
So a lot of members, many members.
Yeah, thousands.
Working in these Crown Office, Post Office.
Correct.
Yeah. So you've accepted earlier this morning that there would have been prosecutions of Crown Office employees. You said the CWU didn't know anything about these prosecutions because you didn't provide legal funding for criminal representation. And you've said, as I understand it, you don't think you could, would or should have known about these prosecutions at the time. Is that correct?
Yeah, they were not raised with us at national level. We were not aware of them. I mean, in terms of me saying I was aware of them because I was handed a piece of paper that details prosecutions. That's how I'm aware of them. I think also in some of the questioning I was given in preparing my statement was a question about what legal services the union offers to its members, and we don't offer legal services for criminal prosecutions.
But as a generality, and this is over time, and I think Sir Alan Bates' first raising of the point is around 2003, 2004, and then everything gathers momentum over the years. There were these increasing voices about problems with Horizon and prosecutions, and this was being reported in the media. So my question is, how or why could the CWU, even if you yourself in your role, not understand that issues with Horizon and prosecutions, given they were being talked about in the context of sub-postmasters, might well be involving your members, could also be affecting them?
As I say, from March 2002, so the period you refer to, 2003, 2004, from March 2002, if such incidents occurred, they would go to Andy Fury and his department to deal with.
I mean, I understand it wasn't you personally. I'm talking about the union as a whole, looking at its members and issues that were coming into the public domain, were in the public domain. How is it that the union itself couldn't understand it, that those issues might be affecting their own members, even if they weren't hearing about actual criminal prosecutions of their own members?
I mean, I think the point I've made and tried to make is that the union is made up of a number of sections, and those elected to the top of the union have completely different responsibilities. So the responsibilities for dealing with any issues that would arise for our members directly employed by Crown officers would go to and rest with what I would call a postal executive, which is under our rule book, which has the sole responsibility for dealing with those issues. So it's not that the union in total would be aware of all of those issues, because it's not why everybody employed by the union is not employed to deal with everything that the union faces. So individuals and elected groups are responsible for specific different aspects of the work we undertake. So we have a nationally elected executive that deals with all issues relating to our members employed within the postal industry, which includes the post office, and we have a lead assistant secretary who deal with various businesses. In this case, my responsibility up until March 2002, and then Andy Fiore's responsibility.
So would it be fair to say that the CWU, whether it was you or whether it was Andy Fury, but the CWU is joining the list of a rather long line of people and organisations who were simply incurious about Horizon?
No, I don't think that's fair to say.
Well, you've said that you didn't know anything about it, and that despite media coverage, no one was prompted to look at the issue for CWU members. So I'm suggesting to you that that is indeed being incurious.
No, I don't think I said I didn't know anything about it. I also, on a number of occasions, I've been quite specific about where the responsibility lies in a large trade union like ours to deal with these issues on a day-to-day basis.
Just
Well,
to
let me just ask you, Mr. Kearns, clearly I understand what you're telling me about the demarcation of responsibility, but would you expect that the relevant heads of the section which deals with post office employees and sub-postmasters would have had information about the numbers of people who are either being prosecuted or dismissed on the strength of information from Horizon?
If that information somehow was given to them, either by the post office or by our reps or members.
Well, when you say somehow, were there any processes in place, so far as you know, perhaps you don't know, which would allow information, such as I've just suggested to you, to go up the ladder from the local reps, where no doubt it would have started, to the senior people at the head of the relevant section?
If those were issues of concern to our representatives at local level, at area level, regional level, they would be passed up through briefings and meetings that our executive and national officers would have with those representatives on a regular basis. So if those were issues of concern, then yes, that would be the process.
Yeah.
Through the policy procedure.
Without wishing to put words in your mouth, is this a fair summary that you would expect that if local representatives were concerned about issues such as prosecutions or dismissal on the strength of Horizon, they would have ensured that it went up the ladder to more senior people?
That's a fair summary, yes.
Fine. All right. Sorry, Ms. Watt.
Thank you, sir. Just picking up and following on from that and earlier questions, you were referring in some evidence with Ms Hodge to the former NFSP members, such as Mark Baker, coming over to the CWU because they were dissatisfied with the NFSP. I think it's fair to say it's a matter of public record on their part, certainly at least Mark Baker's part, that this was largely to do with the dissatisfaction about the way in which the issues on Horizon were being dealt with by the NFSP. Now, even if it was the case, for instance, that the post office wouldn't talk to the CWU about sub-postmasters at the time, this is around 2011, because they only wanted to deal with the NFSP on sub-postmasters, surely any concerns being brought to the CWU by Mark Baker and others about Horizon would have been another way that your union was alerted to problems with Horizon that could be affecting your own Crown Office members, and you could have raised it with the Post Office then. Would you accept that?
That would be as I said earlier, that would be, if Mark Baker has represented those to Andy Fiore, who was dealing with those issues in 2011, that would have been a way of raising them with the Post Office, yes.
But it just never bubbled up to the relevant surface of the CWU, is that
Sorry,
where
it didn't bubble up?
Yeah, it didn't go through those layers that you described to the chair there of how matters come up through to the top of the CWU and perhaps then go to the Post Office.
Well, again, I know people might get fed up with me repeating this, but after 2002, that wasn't my responsibility, so I'm not aware of which issues bubbled up, as you describe it, through that rep structure to Andy Fiore and what then transpired after that. Because
Did the postal executive of the CWU ever bring issues about Horizon concerns and Crown Office employees to the Executive Council of the CWU that you can recall?
Not that I can recall.
You were just a couple of more questions. I think you were just discussing there towards the end of your evidence about self-employed sub-postmasters and collective bargaining. I think you've been discussing and you'd agree that self-employed sub-postmasters running small businesses are quite a different beast to large-scale groups of employees, such as postal workers on collective bargaining. Would you agree with that?
Yeah, they are different groups.
One final question. When I asked you questions on the last time you appeared, you agreed it was likely that post office employees, such as auditors and others, were or could have been members of the CWU. I think you'd agree that would likely also include investigators as well. Would that be right?
When you say investigators, you mean
those who carried out an investigation function, people who were formerly counter clerks and then investigated shortfalls and discrepancies. In
the audit team, you mean?
Yeah.
Yes, a number of those were.
Yeah.
Yeah.
Members
of certain members of the audit team were members of the CWU. Managers of the audit team were not
CMA.
members of the
We heard
Communication Managers Association.
Yes, we heard that. We've also heard much evidence about the aggressive bullying and intimidating tactics used by investigators and auditors, and I just wanted to ask what you have to say about that behaviour and what the inquiry's heard about the way in which auditors and investigators operated.
So I only saw a snippet of one of the post office investigation branches giving evidence. I've had experience of the post office investigation branch as it was then in my day job when I was a local rep, having represented people who've been accused of theft. I do find their methods to be aggressive. I do find their methods to be almost, natural justice is innocence until proven guilty. My experience of sitting down alongside our members facing the post office investigation branch, there's a strong belief in the post office investigation branch where people are guilty, and they're there to ensure that there are consequences to that. I don't find it generally that my experience in the past, it's a long time since I've had any dealings with post office investigation branch, is I find them to be aggressive, not always. I wouldn't trust them.
So, to the extent that any of those were your members, is this something that you could or should or would now provide training to your members in how to conduct themselves?
Train to our members?
Well, the ones who were members who are conducting those kind of
our reps.
Yeah,
we provide, as I said earlier, we provide training for our reps.
Sorry, not your reps, the members who are actually conducting themselves in this way. Do you consider the CWU as an obligation to perhaps remind its members of how to conduct themselves when carrying out their functions?
Sorry, members of the investigation branch who are not members of the CWU. Mm-hmm. Members of the audit team.
Audit team, yes.
But the audit, we're talking about two different things. The investigation branch, who sit down and accuse people of theft or wrongdoing. The audit team, so the audit team predominantly in Crown offices, individual stocks and the office balance is conducted on a Wednesday evening. Predominantly, audit teams would arrive before the opening of business on a Thursday morning, and do a full audit. So they would audit all the individual stocks and the whole office balance to check that the closing balance that the office and the individuals declared on a Wednesday night was in fact accurate. Those staff who carried that out were CWU members, but they were not the ones who would be interviewing individual members of staff and accusing them of, for example, theft. Excuse me. That was the Post Office Investigation Branch. Two separate bodies within the Post Office.
But those individuals might have been the ones out in the field dealing with sub-postmasters. That's what the evidence has heard. Would you accept that?
The audit team?
Yeah, members of the audit team.
Yes.
Okay, thank you. Those are all my questions. Thanks.
Right, Ms Hodge, where are we with this document?
So I don't think there's any need to show it in the end. I think the questions were posed in a more general way. So that concludes the questions from the recognised legal representatives.
Right.
And the witness may be released.
Yeah. Thank you, Mr. Kearns, for reappearing at the inquiry and answering further questions. I'm grateful to you. So, is it sensible to break for lunch now?
So I think so, yes.
So we'll resume at 20 to 2?
Yes, thank you.
All right, fine.
Afternoon, sir. Can you see and hear me?
I can indeed.
Thank you. We are going to hear from Kay Linnell.
Yes.
Yes, please. I'd like to repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and nothing but the truth.
Thank you. Thank you.
Please could you state your full name?
Kay Catherine Sheila Hilary Linnell.
Thank you for attending the inquiry to give evidence today. You have produced a written witness statement. Could I ask you to turn that up, please? Do you have it that's in front of you? Excellent. It should have the date in the top right of the 16th of May 2024.
Yes, it does.
Thank you. For the record, that unique reference number is WITN 00550100. Now, before I go to your signature, could I ask you to turn to page 24, please? Paragraph 91. It doesn't need to be shown on screen. You, on the first line, refer to Joe Swenson. Swenson's well, spelt with an E. I understand you wish to correct that to Swinson spelt with an I.
Yes, please. A spelling mistake. And it's the first of two paragraphs 91, which is a numerical mistake.
Yes. Could I ask you to turn to page 41, please?
Yes.
You should see paragraph 157, and then below that, a statement of truth with your signature.
That's my signature, thank you.
Thank you. And could I ask, are the facts in that statement true to the best of your knowledge and belief?
They are.
That will stand as your evidence in the inquiry, and it will be published shortly on the website. I'm going to ask you some questions about it, but before I do, I understand you'd like to make a statement.
Yes, please, thank you. Before I start, I'd like to say this is a good opportunity to pay tribute to those who worked very hard behind the scenes to help the SPMs to right the miscarriage of justice that has been brought to light. There are many unsung and unseen heroes, and I've been personally supported very strongly by Howe & Co in this matter, and before that by Freeths in the High Court litigation and by other firms such as Hudgels. I would like to pay my respect and thanks to them because a lot of what they've done has been unpaid and unnoticed. Their support continues. One other person I would like to nominate for a special vote of thanks, so to speak, on behalf of the SPMs and myself, is Barbara Jeremiah, my business partner. I slightly blame her for becoming involved in this because Barbara always believed in Joe Hamilton's innocence and would not believe me until we got involved. Joe is our local postmistress, or was, and Barbara's worked tirelessly providing support, guidance and encouragement to many sub-postmasters in the very many years we've been involved. Barbara's been involved in almost 20 years and has never once wavered from her steadfast belief against impossible odds. Barbara's never refused a request for help from any SPM and has always been mindful of the damage inflicted on them and their families by the malicious, incompetent, coercive, controlling behaviour of the shape-shifting post office. We will continue to give support to SPMs in every way we can through accountancy, taxation, counselling and advice, and any SPM who needs advice should contact us until the money wrongly extracted from them and the damages to compensate them have been paid in full. The new post office team appear to be no better organised than the old one through recent events, but I will not mention that. Thank you.
We are not going to cover any recent events. We'll look at matters in the inquiry's terms of reference. I'm going to start with your background, please. And you qualified as a chartered accountant in 1979.
Correct.
And you now work as a forensic accountant.
That's correct.
When did you first start to act as a forensic accountant?
Possibly in the late 80s, early 90s.
And from that point, the late 80s, early 90s, did you work for a firm or on your a self-employed basis?
I began engagement with fraud when I was a partner in a small firm of chartered accountants in Derby. And having discovered fraud, I applied to and joined the Inland Revenue and ultimately became the Board of Inland Revenue's Chief Investigating and Prosecuting Accountant and Head of Accounting Profession, prosecuting several well-known figures. I then left HMRC as it became, and I set up the Joint Insolvency Monitoring Unit to monitor insolvency practitioners. I've also worked in industry for Forte PLC as head of UK taxation, and I then went back into the profession with a small London firm of accountants, and I was then headhunted by Smith & Williamson to set up a Southampton branch as a forensic accountant, and latterly by BDO. In about 2010, I set up my own practice.
So when you were first engaged in or involved in matters relating to SPA Subpostmasters, for whom were you working at that stage?
I was working for myself. It was about 2012.
And I think you mentioned BDO you were employed by BDO, did you?
Yes, I was the forensic director in Southampton.
What was the full name of the BDO, sorry?
I think at that stage it was BDO LLP, I forget.
Could I start with your initial interaction then with Subpostmasters and the Subpostmasters cause? Could we please bring up the witness statement at page 2, paragraph 5? If you could go to page 2, please. Thank you. And if we could have paragraph 5 at the top. So you say I became involved in the post office treatment of its subpostmasters in 2009 because of my local subpostmistress, Jo Hamilton. You then referred to your business partner, saying you used to drop into Jo's shop in South Warnborough to buy her lunch on the way to court. One day in 2005, she found Jo in tears because of ever-increasing unexplained shortfalls in her business accounts. And you go on to describe some aspects of the criminal trial. Can I just clarify, were you first made aware of Jo Hamilton's case in 2009?
No, earlier than that. And I did try and get involved in 2009, but my real first involvement with Sir Alan was 2012.
Thank you. So is it fair to say that you were aware of some facts of the issues, you were aware of Miss Hamilton's case before before you came involved with Sir Alan, but it's only at that later stage in 2012 when you became involved?
Yeah, you could almost say I sort of got my hands dirty from 2012 onwards, but I was well aware of it much earlier than that.
That can come down, thank you. You go on to say that your business partner suggested that you spoke to Jo Hamilton in June 2012.
Yes, that's right.
And at that point, you were, I think Miss Hamilton suggested that you spoke to Sir Alan.
That's correct.
Now, had you heard of Sir Alan before before you spoke to him?
Yes, indeed. Mrs. Hamilton told me all about him regularly.
And can you recall your initial meeting with him?
I met Sir Alan outside James Arbuthnot's office in a first meeting which we were going to have with James Arbuthnot and Ron Warmington and Ian Henderson of Second Sight.
So I'm going to come to that meeting shortly, but that's the first, effectively.
That was my first physical meeting. I had had a couple of telephone calls with him.
I just want to ask a few points about representation generally, and starting with the JFSA. At paragraph 9 of your statement, you say that JFSA is an unincorporated affiliation with no constitution, rules, or hierarchy, but simply united by a common problem, which is to get back the money wrongly taken by Post Office and attempt to recover losses and damages caused by the Post Office operation of the Horizon computer and support system in the Subpostmaster Post Office network. You say no hierarchy. Was Sir Alan the chairman of the JFSA?
In one way, he was effectively the person driving a campaign, and the SPMs that I met preferred that he led the way for them. I don't think there's an officially recognised hierarchy or structure where there's chairman, a secretary or treasurer or anything like that.
And how was decision-making on behalf of the JFSA as a whole? How did that decision-making happen?
It happened at group meetings by show of hands.
When you joined it, when you first met Sir Alan in 2012, can you recall roughly how many sub-postmasters or former sub-postmasters formed part of the JFSA?
I don't know that information.
Do you know how the JFSA was funded at that time?
My understanding is it had no funding.
At that time, had you had any contact with the NFSP?
None whatsoever.
Let's go then to the meeting in July 2012, and I think you say that that was with Sir Alan, Ron Warmington, Ian Henderson and Lord Arbuthnot.
Correct.
Before that meeting, what had you been told about the purpose of it? The purpose of the meeting.
I was told the purpose of the meeting was to consider a mediation proposal put forward by the Post Office.
So, did you say mediation proposal?
A mediation proposal put forward by the Post Office to James Arbuthnot, which he wanted JFSA to sign up to try and resolve the, I think it was 47 MP complaints about SPMs.
Pausing there was obviously the mediation scheme, which we'll come to after the interim report in 2013. This in July 2012, prior to the second site interim report. Was this still described to you as a mediation proposal?
My recollection, which may not be that accurate at this remove of time, but my recollection was there was looking to be a mechanism to resolve the disputes effectively raised by the 47 SPM complainants through their MPs. And they wanted an initial external independent forensic firm of accountants to look at it.
And prior to that meeting, had you had any experience of or dealing with either Ron Warmington or Ian Henderson?
None whatsoever. I looked them up before meeting them, but I wasn't certain that they weren't people put up to do a whitewash burial job by the Post Office.
So we can actually bring up your witness statement, please, at page 4. And there you say, I was extremely suspicious of Second Sight as they had been nominated by Post Office as independent forensic accountants. And I was concerned that their access to documents and review of Post Office's Horizon system might be a whitewash. I challenged them at our meeting in 2012, but was satisfied with their responses. Can I ask you, your recollection of how you challenged them at that meeting?
I recall I asked them various questions about their background and approach to what ended up being the spot reviews of the cases.
And do you recall what they said to satisfy you?
Not precisely, but I wanted to know what documents they were going to look at, what level they were going to look at in the IT support, and whether they were going to meet the complainants.
You said in your evidence then what ended up being the spot reviews. Had the concept of, from your recollection, was the concept of spot reviews discussed at that meeting?
Not to my recollection, no.
Do you recall broadly what the proposal from Second Sight was?
I think the initial proposal was to pick several of the 47 cases and do an in-depth review of each of them to try and find out what had gone wrong and whether the complainant had any substance in what they were saying.
So that at that stage, a focus look into specific cases raised by MPs.
Yes.
Lord Arbuthnot produced a witness statement and gave oral evidence to this inquiry. The witness statement was dated the 12th of March, and he recalls this meeting taking place on the 12th of July 2012. And his evidence was that you and Alan agreed, or were satisfied and agreed to the appointment of Second Sight at that meeting, with the caveat that you would be able to double check that Second Sight were acting independently. Would you agree with that?
Yes, that's correct.
And at that point, how did you envisage checking on Second Sight's independence?
At that stage, I thought I would be acting as an independent forensic accountant for JFSA, and I believe at the time I prepared a letter of engagement, and it was agreed I'd be paid a small fee for checking their work and going round with them, just to see what they were doing.
Let's look at that letter of engagement now. It's exhibited to your witness statement at WITN 20550-101. Is this the letter to which you were referring?
Yes, it is.
It's dated the 6th of July 2012, so shortly after the meeting with Lord Arbuthnot and Second Sight.
16th of July 2012.
16th, sorry, did I say the 6th? I do apologise. 16th. If we could go down, please. And we see scope of our work. It says, well, firstly, a sentence about acting as expert accountant. And
Yes.
refers to Second Sight. The second sentence says, the initial investigation will be in two parts. The first being into current errors, the second to investigate the historic cases which have been raised by MPs and a number of cases you will recommend.
That's correct.
So is that broadly what Second Sight were suggesting at this time, or at least your understanding of it? A look at first tranche current cases and then more historic ones in a second tranche?
That was my understanding.
At this stage, was there any discussion from your recollection of systemic errors or looking for systemic errors?
No, not at all.
That document could come down, thank you. And if we could bring up the witness statement, please, page 4, paragraph 15.
Before that comes up, Mr. Stevens, can you remind me to whom that letter was addressed? I saw that it was on Mr. Linnell's note paper, but to who, it's dear sirs, is there a...
Yes, the addressee is Justice for Subpostmasters
Right.
Alliance.
Yeah.
But actually, so you're quite right. The question I should ask, if it's an unincorporated association, is to whom was that letter sent?
It was sent to Alan Bates.
There we are on the witness statement. So paragraph 15, you refer to attending a meeting at Post Office with Alwyn Lyons and Paula Venables. You say, I think, around June or July 2013.
That's correct.
Had you met with Alwyn Lyons and or Paula Venables before then?
I don't think I'd met Alwyn Lyons before then, and I think I had seen rather than spoken to Paula Venables. There was a briefing day in the September of that year when I definitely met them, but I don't recall meeting them before then.
And the interim report is produced on the 8th of July 2013.
Yes.
Was this meeting before or after the interim report?
Unfortunately, I can't find the date, but I believe it was before the interim report was released.
But you're confident that it was 2013 and not 2012?
Yes.
We'll come back to that meeting then in due course. Can I please ask for us to look at POL 30911028? If we could go down, please. Thank you. So we have a email from Ronald Warmington to Mike Wood MP. You're not in copy to this, so you wouldn't have seen it at the time, presumably.
No.
And have you seen it for the first time when preparing for the inquiry proceedings?
That's correct, yes.
The second paragraph of that email says, the idea of carrying out a deep dive into Horizon is on hold until we have completed the case reviews. Few of us think that sort of review will work well. Some of us think it will probably turn out to be a colossal and expensive disappointment for those seeking evidence of anomalies in Horizon. Those pressing for such a review now seem happy to wait to see what the case reviews throw up. Do you have any recollection of between the meeting you had with Second Sight on the 12th of July and this meeting on the 18th of July, of any discussion about a deep dive review or specific case reviews?
No, we only had the one meeting to start the process off. I think it's referring to our first meeting.
And at this stage, you were happy with the case reviews approach?
I think if you didn't approach it through case reviews, you wouldn't know what anomalies you were looking for. You'd be checking 100% of the system at vast costs, and it would take an enormous amount of time. So I do agree with starting with the problems and then working back to see what went wrong.
Thank you. That document can come down. Please can we bring up your witness statement at page 11, paragraph 47. Thank you. Now, this is something I've already touched on. You say here about the distinction between systems error and systemic error. You say that it's worth noticing the difference between a systems error, brackets, that is an IT coding error that will replicate an error of the entry of the same data and processing of transactions in the IT system, close brackets, and a systemic error, open brackets, that is one caused by incorrect implementation and management of the Subpostmaster network using the Horizon computer accountancy system. Were those concepts, of, as you described them there, discussed with Second Sight in 2012?
I think the first time the word systemic error was used was in a letter from Sir Alan to, I think, James Arbuthnot. And the difference between Ron and Ian's definition of systemic errors and ours is theirs was restricted solely to the computer system, whereas Alan and I saw and see Horizon as to be a complete system of administration, training, implementation, and management using the computer Horizon.
Could I, do I take it from that then that there wasn't a discussion with Horizon on the difference between systems error and systemic error in 2012?
Not that I recall.
Could we look please at the interim report? It's POL 30099063. And if we could go to page 22, please. So this is an appendix to the interim report, which sets out what says the remit of the inquiry. So the remit of the inquiry will be to consider and to advise on whether there are any systemic issues and or concerns with the Horizon system, including training and support processes, giving evidence and reasons for the conclusions reached. Do you recall when the first time you heard the inquiry expressed like in those terms was?
I think it was on the publishing of this report, which I didn't see in draft before it was published. I just saw the final version.
Keeping at the time when the Second Sight review was commissioned, so July 2012, what at that time was your view of the Post Office's motivations for commissioning that review?
Personal opinion is that they wanted to settle the MP's complaints and make it quiet.
What was that based on?
It was based on the attitude of the Post Office in falling over themselves to provide information about those particular cases and nothing else.
In your view at the time, what, if any, other options were open to the JFSA to push forward with the Subpostmasters' concerns?
The JFSA were an alliance of people who had similar problems with the Horizon system, who'd suffered personal damage, but had no information whatsoever. If it could be taken to the next stage of taking it to the court, the SPM's JFSA required evidence, and there was no way of getting evidence from the Post Office except through MP complaints. So there was no other course of action they could have taken at that stage, in my personal opinion. On Tuesday, you'll know that they're not backward at telling their views about things. So, yes, they had.
And what's your recollection of what they said?
My recollection was they found sufficient errors, defects and problems that the complaints by the sub-postmasters through their MPs were generally being found to be based on errors in the Horizon system.
At that stage, how satisfied were you with the work that they had and were carrying out?
I was very satisfied that they were trying to do their best to get information from Post Office to answer the question we'd all been asking, why have these differences occurred?
At that stage, so January 2013, had either Mr. Warmington or Mr. Henderson mentioned a concern that there may have been miscarriages of justice?
No, we didn't discuss criminal prosecutions or miscarriage of justice. We were simply looking to try and find out why the errors had occurred.
Please could we bring up poll 30988315. So if we can move down the page slightly, please. Thank you. We have an email from Sir Alan to Ron Warmington on the 12th of May 2013. I believe that our data protection has covered up the email address, but I believe that's you in copy. Is that right?
Yes, I was copied.
It's responding to quite a lengthy email from Mr. Warmington, which I don't need to take you to. It's the, as you may expect, it's the system errors and systemic failures that I want to deal with. And it says, I think there may be at times confusion by others over the referencing of these 2 points. At its most basic, system errors would to me be something like an extra loop in the software code causing the false result of a transaction. But as you rightly say, that would affect every one of the 11,500 officers. Then at the other end of the scale, it might be something far more complex, resulting from a network communication failure and an incomplete recovery of a transaction at a particular office. It goes on. And Sir Alan goes on to say, now systemic failures, on the other hand, are different. And in my letter to James Arbuthnot, now pausing there, was that the letter to which you referred earlier in your evidence as the first time you recollect this issue arising?
Yes, that's my recollection.
You see, where I first used the phrase, I've qualified its context. This occurs in the first sentence of paragraph 2, where I say, the weight that it adds to the systemic failures with Post Office and their Horizon system. It is these systemic failures with Post Office and their Horizon system that are the proven facts. Now, do you agree with that definition of system errors and systemic failures?
Yes, I do.
Did you have any further discussion on that distinction with any representatives of Second Sight following this email?
No, I left this to Alan because he had some experience in point of sales and software, and frankly, I'm too old. I'll use pen and ink, really.
Before we move to look at the interim report itself, to what extent were you aware of Fujitsu's involvement during the... Sorry, I'll rephrase that. To what extent were you aware of Fujitsu being consulted by Post Office during the Second Sight investigation?
I assumed at this time that Fujitsu held some of the electronic evidence and data, and they would have to be asked by Post Office to produce it. I'm not aware of any consultations.
So is it fair to say that was an assumption you made because they operated the computer system, but you had no direct knowledge of Post Office contacting Fujitsu?
Not at that time, no.
At that time, had you heard of Gareth Jenkins?
No, I had not.
I said it would be before I moved to the interim report, but of course I put off the question I was going to ask earlier about a meeting with Paula Venables and Olwen Lyons. Could we please bring up your statement at page 4, paragraph 15? Paragraph 15, please. Thank you. So you refer to, again, this meeting in either June or July 2013, and my understanding is that this was before the interim report came out. That was your evidence earlier.
Yes, that's correct. And I believe it was requested by Post Office. We'd written and asked for a meeting, I think, on around the beginning of June 2013. And the date was suggested by, I think, Paula Venables.
Well, let's see if we're thinking about the same email. Could we bring up POL 30988418, please? And if we could go to the bottom of the page, please. So there's an email there from Sir Alan on the 21st of May 2013. And the second the last paragraph on the page says, would it be possible for Kay Linnell and I to meet with you? Is that the email you were referring to?
Yes, and I think there's some subsequent emails where she comes back. And I think a date of the 5th of June was suggested, but that wasn't convenient. Yes, it's down there at the bottom of the page.
So, looking at this email, Sir Alan refers to you and your who you were as a reminder. If we can go down, we see that he says that the main purpose of the meeting is to ensure that you've been receiving the full details of what has been occurring with the second site investigation. Bearing in mind what has been discovered so far, I, for one, am surprised that we haven't yet met to discuss the implications. Now, pausing there, at that stage, what had been discovered so far that prompted an email from Sir Alan? I should just ask, sorry, did you and Sir Alan discuss this before sending it?
Yes, we regularly discuss things and swap drafts. And as I recall, what had been discovered is there had been substantial and important errors in the operation of the computer, which had caused differences and shortfalls in SPM's accounts. And it was at this stage we had, from the spot reviews, evidence that Horizon did not operate perfectly and left differences.
It goes on to say, at the final sentence of the paragraph, I have little doubt that it is now feasible to show that many of the prosecutions that Post Office have pressed home should never have taken place. And I believe this is a view shared by Kay. Was that a view shared by you?
Very much so.
And again, just so we're clear here, what was it at that stage that led you to believe that it was feasible to show that many prosecutions should not have taken place?
Bearing in mind I had personal knowledge of Jo Hamilton's case, and her case was taken to the doors of the trial before a plea bargain without any evidence being given to Jo to check as to how and why the errors arose. When Second Sight started their spot reviews, they also found that there were errors which hadn't been disclosed to people who were prosecuted as part of the spot cases.
Just pausing there, when you say errors, can you remember, putting yourself back to the time, what those errors were which led you to believe this?
I can't remember which names the bugs had.
But is it bugs that you're referring to?
It's bugs. And everyone's called them bugs, but they're actually errors in the computer software programming that when you put in a certain series of transactions always cause a difference. And as the post office read the contract, that it was always the sub-postmaster's fault or liability, whatever the circumstances, it was clear to me that money had been taken wrongly, and also, as in Joe's case, they had relied on the computer figures to mount a prosecution, and I therefore felt at that stage prosecutions might or probably were unsafe.
Was that the prosecutions being unsafe? Let me rephrase it. Who did you discuss your concern that prosecutions may have been unsafe, other than Sir Alan and, by way of this email, Paula Venables?
Nobody, because it's a suspicion, not evidence. And as a forensic accountant, I have prosecuted people while I was at HMRC Inland Revenue, and I am aware of the standard beyond reasonable doubt and the evidence required to show criminal intent, none of which appeared to be present in Joe's case. But I was not aware of sufficient evidence to take that anywhere else. It was a suspicion.
The last question I'd like to ask on this email is the use of the words, the main purpose of the meeting is to ensure that you have been receiving the full details of what has been occurring. Do you know why Sir Alan used that turn of phrase?
We actually discussed this. It's a question we thought of the post office being a former government organisation which had silos, where, for example, the legal department appeared to be completely separate from the operation and management department of the post office network, and there appeared to be management layers between them and the board and the CEO. So Alan and I wanted to make sure the people at the top knew exactly what had been found.
If we then can go back to the meeting which we had in your witness statement. So if you could bring back page 4 of the witness statement, please, paragraph 15. So it says that we asked to meet Paula Venables, the CEO, to try to get a reality check on the Post Office opposition to recognising the plight that Post Office had caused sub-postmasters, to admit Horizon was not 100% perfect, as no computer system can be, and to get money paid back to sub-postmasters as soon as possible. Going to say, at that stage, JFSA did not want a full public exposure, just proper care for SPMs in giving money back wrongly taken and paying for losses and damages. We were asking for substantial amounts, but nothing compared to their own bonuses, published in great detail in the Post Office Limited annual accounts. There you don't refer to prosecutions. Did you not discuss that with Paula Venables at this meeting?
As far as I can recall, we discussed everything, and we were slightly worried that they'd used no evidence at all to mount criminal prosecutions without any idea of whether there was a guilty mindset or not. But I didn't refer to it there because I am not certain. I don't have any notes of that meeting. I can't even find the date of it, unfortunately.
From your recollection, what do you think you said to Paula Venables and Alwyn Lyons about your concerns as to criminal prosecutions?
I believe Sir Alan and I have always been concerned about giving money back to sub-postmasters who were in dire financial straits, having had money taken away from them. And the thought about prosecutions was something we suspected but couldn't prove or worry about. As in 2013, so many years ago, we wanted the money given back to people it had been taken off. And that still is a primary concern. And, you know, I'm sorry to expand on the answer, but I recall that all we got from Paula Linnell's was her main purpose was to learn from the past and build the brand and make it profitable, which is not an answer to our questions at all.
Do you recall there being any discussion on or proposal put forward by either Alwyn Lyons or Paula Venables that went to concerns about either criminal prosecutions or giving money back to Subpostmasters as you requested?
No, none.
Okay, that document can come down, thank you. Please, could we, actually before we go to that, the interim report is, we know it's published on the 8th of July 2013. What, if any, involvement did you have with looking at or discussing drafts of the interim report with Second Sight?
None whatsoever.
Did you have any discussion with representatives of Second Sight more generally about the content of the, not specific drafting, but the content, the general content of the interim report before it was published?
Not before it was published.
What did you understand the purpose of Second Sight releasing the interim report to be? And just be clear, my question is before it was released.
Before it was released, I believe there was some pressure, particularly from James Arbuthnot was my MP as well as Joe's. And I think there was some pressure from the MP committee, led by James, to actually give some sort of interim report as to what the Second Sight investigation was finding. So I believe they selected a few cases, 4 or 5, and produced effectively a distilled analysis of them. Before they produced it, I expected it to be a full, in-depth analysis of them.
That purpose of producing a interim distilled analysis of 4 or a select number of the spot reviews, did you think that was or what did you think of that as an idea?
Not a bad idea, because it might start the ball rolling towards giving money back, I thought. And as long as it's only a stepping stone along the way in their inquiries, it wouldn't make any difference.
Was there any discussion before the interim report was published as to what was envisaged to happen to Second Sight's investigation after it was published?
No, I don't believe there was a discussion. I think there was an understanding that the Second Sight investigation would continue until they'd finished the Subpostmasters complaint cases, the ones from the MPs.
Sorry, I
No, beg your pardon.
I overcut you there. I was about to ask. You said until they've finished the Subpostmasters complaint cases, and then did you say the ones from the MPs, as in the cases referred by the MPs? And
I think they were augmented in some way by a few added by Post Office as sample cases from memory.
You referred to an understanding that Second Sight's work would continue. When you say that understanding, was that just your understanding or one shared by others?
The original engagement of Second Sight was by the MPs, countersigned by JFSA, and Post Office were used by the MPs as a vehicle to implement the contract and pay, because the MPs did not have a budget. So my understanding is the MPs were instructing Second Sight, nobody else, and the MPs wanted an answer to their queries.
Could we look now at the interim report, please? It's poll 3099063, and if we could look at page 8. The preliminary conclusions are very well known to the inquiry. We see that no evidence of system-wide (systemic) problems, and B, referring to 2 incidents or aware defects or bugs in the Horizon system, and it goes on to refer to two of the bugs that the inquiry has heard a lot about. What did you think of, in particular, these two preliminary conclusions at the time?
I was particularly disappointed by conclusion A, because I didn't think there was sufficient data for Second Sight to reach that conclusion. I don't think they should have opined at all on whether there were systemic problems at that stage. I also found in my own research, following them round, that they had found problems across the system where one error would affect many, many branches, and I was therefore disappointed.
Just taking that in stages. Firstly, you say that disappointed because they didn't think they had the evidence to say that. The fact they've said we have so far found, so saying we haven't found evidence of a systemic problem, did that not reassure you?
Quite the opposite. It made me think Post Office had interfered with the report.
And when you said that you felt you had seen evidence of system-wide systemic problems, do you recall what, at the time, what you thought those were?
No, I can't recall. There was something to do with ATMs, but I don't remember whether that, and it was the Bank of Ireland, but I'm sorry, my memory of that is very hazy. I just remember being quite cross about this because they shouldn't have put anything in without the evidence to support it. And from what I'd seen of Ron Warmington and in Henderson, they were very thorough. So I don't believe on their own they would have written that.
But just to be clear, you weren't involved in the drafting process, so you don't have any direct knowledge of how this report was drafted?
None whatsoever.
Can we turn to page 12, please? This is Spot Review 5, which concerns the allegation that had been made by Michael Rudkin regarding what's now referred to in shorthand as remote access. And the inquiry has seen this a lot. I don't need to go through it in full. If we could just look at the bottom of page 13, please. Saying we are left with a conflict of evidence on this issue and our inquiries are continuing, particularly in the light of new information confirming that the meeting on 19th of August 2008 did in fact occur. Were you told anything about Fujitsu's ability to access data or insert data into branch accounts remotely prior to the issuing of the interim report?
Yes.
What were you told?
I was told it was possible to enter the system through a back door and it was a systemic error.
Who told you that?
Well, believe it or not, I think it was Ron Warmington, but I've certainly talked to Sir Alan about it, and we knew about the Bracknell and other parts of Fujitsu who regularly made corrections to the live system.
So you spoke about it with Sir Alan, and I think you said Ron Warmington discussed it with you. At this stage, so when the interim report was released, were you aware of Gareth Jenkins as a person?
No, I'm still not aware of Gareth Jenkins at this stage.
You say in your statement, we don't need to pull it up, that you thought the interim report could have been much stronger with regard to the Post Office limited field of operation and systemic working errors. And in your overall evidence, you've expressed frustration about the report. Did you discuss that with did you discuss your feelings on the report with either Mr. Henderson or Mr. Warmington at the time?
After the report was issued, yes.
What did you say to them?
I was disappointed.
And what was their response?
I don't exactly recall what they said, except that, they'd had to discuss the draft with Post Office and clear it, which I still don't understand.
I want to now look then at what happens next in the chronology. It's the mediation scheme. Were you involved in any discussions with post office representatives following the publication of the interim report about what to do next following its findings?
Yes, there were extensive discussions, generally led through James Arbuthnot and Alan Bates, about how we should go forward from the interim report. Because although I thought they'd carry on finishing the job, it was clear they wanted to take a different line.
And when you say it was clear they wanted to take a different line, how did you come to learn of that? And when you say they, do you mean post office?
Post office, I'm sorry, I should say. Post office wanted to be seen, in my view, as reacting to the interim report in a positive way.
Were you involved in the initial discussions as to the establishment of what became the mediation scheme?
Yes, I was.
Who else was involved in those discussions?
Sir Alan Bates, Ron Warmington, Susan Crichton, Ian Henderson, James Arbuthnot. Possibly some others.
So on behalf of Post Office, it was Susan Crichton.
Susan Crichton led the discussions.
And can you recall, in terms of dates, when those discussions took place?
They were sometime around August 2013.
What was your view of Susan Crichton's approach to the issues in the mediation scheme?
She struck me as somebody who was trying to get to the bottom of what had gone on and to put forward some redress or remediation for the people who'd been caught up in it.
Do you recall when the working group that oversaw the mediation scheme, do you remember when that first became suggested as an idea?
The working group was merely a part of the mediation scheme, and I think it was called the Initial Complaints and Interim Mediation Scheme, as it's supposed to be a model where we tested whether complainants could get redress. And I believe it started with a training session in September 2013, which I attended with Julian Wilson from the JFSA.
We can, if you look at that now, if you could bring up your witness statement, please, page 18, paragraph 66. So you say, as you rightly say, you said that it was attended by Julian Wilson, and you say that the training day was also attended by Second Sight, and presentations were given by Susan Crichton, Angela van den Bogert, and Andy Parsons. Can you, is this the first time you'd met Andy Parsons, or had you met him before then?
No, I think this was my first meeting with him.
And do you have any recollection of his approach to the training session itself?
The training session was done in such a way to explain the background to the way Post Office operated and its structure, and Andy Parson gave some legal overview. I forget the details precisely.
And Angela van den Bogert, was that your first dealing with her, or had you met her before?
No, this was my first dealing with her.
And again, the same question, what was your view of her, sorry, I'll rephrase that. What was your view of her approach to the training day and the mediation scheme at that point?
Her approach was to tell us sufficient to understand how the network was managed by Post Office and the duties of the sub-postmaster.
Please, could we look at WITN 20550-103? And page 11, please. Actually, no, if we start on page 1, usually a good place to start. I think this is exhibited to your witness statement as a presentation given at this trading day. Is that?
That's correct. This is a copy of the slide deck.
Could we turn to page 11, please? So we see Bond Dickinson at the top. Can we infer from that that it would be Andy Parsons giving this part of the presentation?
This is Andy Parsons' presentation.
And we have possible remedies. I want to ask about two. Can you recall what was said about compensation?
My recollection of this day is quite muddled, to be honest. I have a feeling he said if there is something that's been done wrong, clearly the post office will compensate you, or some wording like that. My notes are also pretty fuzzy because I'm talking to people and presenting as well. But I think it basically was that they would pay compensation to people who had suffered if there was an error proved by post office.
And I appreciate you say your memories, I think the words were quite muddled, but do you recall what was said about support a criminal appeal?
Again, if the evidence, I think my recollection is that Andy Parsons said if there was a proven miscarriage of justice, they would support a criminal appeal. Just as an aside, if I may, you would have thought if they'd known about Gareth Jenkins at this stage, they would have actually told us in the briefing.
Can we look, please, at poll 2022120? This is a document titled Overview of the Initial Complaint Review and Mediation Scheme. Was this a document to which the JFSA had input?
Yes, we had a lot of input.
And was it an agreed document?
In the end, yes. It was compromised in various parts, but it was generally agreed.
Throughout my questions today, I'll come back to this, and there may be points when I ask you where there's been compromise, but I'm not going to ask you for the whole of the drafting by committee. Could I look, please, at page 5? We have frequently asked questions about the scheme, and at the bottom, a bit further down, please. Thank you. What if my case involves a completed criminal prosecution or conviction? So you may put your case through the scheme even if you have already received a police caution or have been subject to a criminal prosecution or conviction. However, Post Office does not have the power to reverse or overturn any criminal conviction. Only the criminal courts have this power. If at any stage during the scheme new information comes to light that might reasonably be considered capable of undermining the case for a prosecution or of assisting the case for the defence, Post Office has a duty to notify you and your defence lawyers. You may then choose whether to use that new information to appeal your conviction or sentence. You may have already answered my question. At this stage, were you aware of the advice of Simon Clark, dated 15th of July 2013, which raised allegations that Gareth Jenkins had breached his expert duties to the court?
I believe the Clark advice was only disclosed in March 2021 after the criminal appeal trials.
At this time, were you aware of the substance of the allegations, namely that Gareth Jenkins had produced expert evidence in breach of his duties to the court?
No, I wasn't aware.
At this stage, were you aware that Post Office was conducting an internal investigation into past convictions?
No, I wasn't aware.
So that might be a good time to stop for the an afternoon break.
Yeah, that's fine. What time shall we resume?
Could we say 3 o'clock, sir?
Yeah, by all means.
Thank you. Sir, can you see and hear me?
Yes, I can. Thank you.
Thank you. I want to carry on with a few points on the mediation scheme now. Could we please have your witness statement on the screen, page 20? Go to the page before, please. Thank you. And at paragraph 76, you refer to Belinda Crowe as being the appointed administrator and act as secretary to the working group.
Correct.
You say at 77, I was not aware at that time that Post Office had a separate committee chaired by Belinda Crowe called Project Sparrow, which was only revealed after the High Court trials. The fact that JFSA did not know about this is typical of Post Office Limited's behind-the-scenes obsession with secrecy and control. At the time, did you have any concerns as to the appropriateness of Belinda Crowe's appointment as a person to provide secretarial support to the working group?
I didn't know anything about Belinda Crowe except she was a post office employee. I'm not sure that anybody else was able to afford the services of a secretariat to manage the case flows and assist with the disclosure exercise of Post Office, which was headed up by Angela van den Bogaert's investigation team. And I just accepted her as someone nominated to do a job. But what I wasn't aware of, which is what those two paragraphs indicate, that she was senior in Post Office and not just a secretary or somebody, and that she seemed to be chairing somebody, well, some group of people who are working against the disclosure and settlement of the cases. It's disingenuous in terms of a mediation scheme.
With hindsight, with that knowledge now, do you have any concerns as to whether or not it affected the mediation scheme or disclosure within it?
I believe it affected the recording of the minutes and the progress of cases through mediation, but nothing else.
And you say recording of the minutes, is that because Belinda Crowe took the minutes?
Belinda Crowe was responsible for the minutes, the case administration, and producing bundles of documents for the cases we looked at an early stage to make sure the system was working properly.
I'm going to come back to the minutes later, so I won't deal with it now. Could we look, please, at page 15 of your statement? At paragraph 55, you refer to minutes for the 30th of January 2014 working group, and you say Post Office sought to narrow the terms of reference and JFSA objected. Chris Ojar went away to review the terms of Post Office and report back. He did not report to any other working group meeting, and to my recollection simply imposed the Post Office new terms unilaterally to restrict the authority of the working group that effectively further slowed up the completion of cases, passing cases to mediation. Can we bring up those minutes, please? That's Poll 30026641. And if we we see it's the 30th of January 2014.
Yes.
If we can just scroll down slightly, please. Thank you. So we see there's a discussion about the terms of reference. And under action, it says Alan Bates raised the issue of scope of the working group and whether the intention was that the terms of reference would replace existing documentation, particularly, but not limited to, the raising concerns about horizon documentation. And secondly, discussion then turned to the purpose set out for the working group, with the point being made that if the terms of reference superseded previous documentation, then JFSA felt the terms of reference as drafted were insufficiently broad. Is that what you were referring to in your statement as the challenge?
Yes. It was an attempt to narrow the terms of reference that the working group could look at.
And in what way was the attempt to narrow the terms of reference?
Comparing the two sets of documentation, the first set, prepared under Susan Crichton, was to embrace the reasons for the differences. The set of documentations, as I recall, the new terms of reference, prepared by Chris Ojard, or someone under his direction, sought to limit anything the working group looked at solely to the Horizon computer system.
And we see there, it says, Post Office, responding for Post Office, Chris Ojard explained the terms of reference accurately reflected the purpose of the working group as explained to him when he had taken over as General Counsel, and that his understanding was that the working group's purpose was narrower than Alan Bates had set out. Pausing there, just as a slight detour, in your statement you refer to a change of tone and approach for the mediation when Chris Ojard replaced Suzanne Crichton. Can you explain what you mean by the change of tone?
Yes, Susan Crichton was a lawyer, counsel for the Post Office, who was trying to find out why differences had occurred. And it was under her instigation, we got two excellent investigators, Ron Warmington and Ian Henderson. It was under her instigation we had a training day for people sitting on the working group to understand the system. So it was a kind of open environment where access was given to documents to try and find the true reason for things. The second she disappeared without explanation and Chris Ojard replaced her, we had someone who appeared to be a litigation lawyer attempting to obstruct any access to documentation, slow things down, narrow the focus onto the narrowest of margins to limit damages for the Post Office. That's how it appeared to me. And
you appear to be suggesting that direction came from Chris Ojard. Was that anything he said or did that made you think that, or was it just a timing matter that once Susan Crichton left and Chris Ojard came, there was this change of tone?
The change of tone was obvious. It's not always reflected in the minutes by Belinda Crowe. But, for example, at the beginning of every meeting, Sir Anthony Hooper would ask, could the Post Office please explain what has happened to this money? Where are the suspense account items? Where has the money from Subpostmasters gone? And this is only referred to in two sets of minutes. One in November 2014. And Chris Ojard says he'll ask his accounts team to answer what is a really simple question, and it simply doesn't recur again. But at the start of every working group meeting, Sir Anthony Hooper asked that question. And Chris Ojard has simply blocked it and stopped anything happening with regard to revealing it. It is clear to me that he's there to close the scheme and close them down and make sure that we don't see anything that damages the Post Office brand. So yes, it was a change of tone and it came from Chris Ojard.
I'm going to look at suspense accounts later. Sticking with the terms of reference, could we bring up, please, Poll 2626656? So this is the notes of the meeting on the 7th of March 2014. So we previously were at the January 2014. We're now 7th of March 2014. If we look down, please, to terms of reference. It says the working group discussed the revised terms of reference. The reworked clause 4.9 was agreed. Clause 4.10.1 was agreed, subject to the addition of the phrase "and any associated issues" after Horizon. It was confirmed that the terms of reference allowed for different lengths of mediation. It was agreed that the working group should not have its own budget, but use the process set out in Section 8 where funding was required. The terms of reference were agreed. Now, the inclusion there of the "and any associated issues" in Horizon, was that addressing the concern you had about the narrowing of the terms of reference?
It was supposed to make sure the previous issues were still included in the working group remit.
Why did you say supposed to?
Well, I don't believe it did. I mean, for example, one of the other things we discussed extensively was the retention of documents required for the cases. And bear in mind, we've got a lot more cases. We've got the 136 now, which is the 150 minus the ones the post office objected to. And every time, again, we'd say, please don't destroy any documents. And Chris Ojard would say, well, if there are issues in those documents and they're more than 6 years old, we'll probably have destroyed the documents. He made no effort to retain documents.
Well, let's look what you say on that in your witness statement, please. It's page 16 of your witness statement. Sorry, no, it's not. It's page 28. Thank you. So this is a section on concerns raised at the working group meetings. We'll be coming back here. I'm just going to deal with the paragraph 108 first. And you say that Sir Anthony Hooper asked how the documents for Subpostmasters and other affected cases were being preserved. He warned Chris Ojard not to destroy any documents at all. Chris Ojard replied to Sir Anthony Hooper that Post Office Limited would continue to destroy documents following its usual 6-year statute of limitations document destruction policy. Can we just look at some minutes on that, please, starting with Poll 30026640. Now, as happens with some of these meetings, we have the standing agenda and attendees there. The date of the document is on the second page. It's the 23rd of January. Would that be 23rd of January 2014?
Yes, it would. These were telephone calls. We only met in person, I think, once a month.
Could we look at page 8, please, under AOB? So action, Post Office to reinforce the point that files not be destroyed. Note to issue in Chris Ojard's name, including letter to Royal Mail and other relevant bodies. Do you recall that being discussed?
Yes, it was discussed at every meeting.
And if we can go, please, to Poll 30026635. And if we could just start at page 2 to date the document, Thursday, 6th of February. If we go back to the front page, please. We see that you're not in attendance at this meeting.
No.
Would you have reviewed the minutes?
Yes, I always reviewed the minutes when they came out.
Could we turn to page 5, please? And if we can go to the bottom of the page under 7. we have review of outstanding actions, and reference number 28, it's the point we went to earlier at AOB, Post Office to reinforce the point that files not be destroyed. And it says update, correspondence issued to Royal Mail and from Royal Mail to Iron Mountain. Was it not the case that Post Office were taking steps, or saying they were taking steps not to destroy documentation?
Well, they said they'd corresponded with their previous head covering Royal Mail, which separated in 2012, and Royal Mail had stored some documents at Iron Mountain, so presumably they told Royal Mail since 2012 and earlier not to destroy documents. It didn't affect really what the Post Office was doing with their own documents. A lot of the cases being reviewed were pre-2012, so that was relevant. But whether it was complete, I can't say.
I want to... can we bring up your witness statement, please? Page 27, paragraph 101. You discuss here a practice by JFSA of retiring during discussion of individual cases. And by retiring, do you mean not participating in the discussion?
We left the room.
Left the room. So there was a development in the working group meetings where the originally agreed terms for the working group were unilaterally varied by Post Office when the working group attempted to discuss cases where Second Sight had recommended mediation. So this is Second Sight do the report, the Second Sight say we recommend mediation, and there were situations where Post Office wanted to have a discussion as to whether or not the working group actually recommended mediation. Is that a fair summary?
Yes, except Post Office had no authority to do that.
No authority to do what, sorry?
Well, at the point that the original terms of reference before Chris Ojard's version was that if Second Sight, having reviewed the claim, the Post Office inquiry report and the CIR by Second Sight, if Second Sight it said it's a case fit to mediate, it should go straight to mediation. Post Office had no right or authority to interrupt the flow to mediation and have a discussion at this point.
Can we look, please, at poll 3022120? It's the same document we went to earlier about criminal, just before the break, about criminal convictions. Could we turn, please, to page 2? If we go down there, perfect, thank you. This is describing the scheme, and the fourth paragraph down says, as a result of this investigation, Second Sight will produce a case review summarising its findings and a recommendation on whether the case is suitable for mediation. A copy of this case review will be provided to you. And pausing there, this is aimed at an applicant, so postmaster, is it? So that you is the applicant?
Yes, this briefing document is for the claimants to make a claim, so it's to encourage them and explain how it will work.
Then says the working group will, however, take the final decision on any cases that may not be suitable for mediation.
That's correct. So any case that Second Sight have rejected or can't make a decision about, the working group should review. Ergo, it means that any case where Second Sight say it's suitable for mediation should go straight through.
Is it not the case that Second Sight would produce a recommendation which it was intended that the working group would then consider and arrive at a final decision?
No, it wasn't. The CRR, if it recommended mediation, should go straight to mediation. It's only cases where they didn't take a final decision.
What was the base? Where did you get that understanding from? That was the proper interpretation of what the working group's role was?
The working group will take a decision, final decision, on any cases that may not be suitable for mediation, not on cases that are suitable for mediation. That's what it says.
If we turn to page 8 as well, please. And will my case definitely be referred to mediation? I think this is a paragraph to which Sir Alan referred in his evidence to the inquiry. That if your case is suitable and you provide accurate, detailed information to second sight, then this is likely in most circumstances. However, the working group may consider that some cases are not suitable for mediation. For example, if there is insufficient information about a case or the case is not one for requiring resolution. How does that work with your interpretation of the role of the working group if it's only going to decide cases for mediation where second sight haven't made a recommendation?
The working group was intended to process cases and make sure they had the relevant information and inquiries made before going to mediation. My understanding, when this document was issued, is only in exceptional or strange circumstances when second sight, as competent investigators, couldn't make a decision or there was insufficient evidence, would the working group consider the case. So it meant that the majority of cases should have rolled through to mediation, and Post Office nor any other party around that table had the power to stop them.
The working group was chaired by Sir Anthony Hooper, a previous Court of Appeal judge, yes?
Yes.
I think Sir Anthony Hooper was your recommendation.
Sir Anthony Hooper was chairman of the Expert Witness Institute and I was its vice chairman. I knew him quite well.
Was the purpose of appointing someone like Sir Anthony Hooper with a legal background to assist with resolving issues such as whether a case can go for should go for mediation or not?
No, that wasn't the main purpose. The main purpose was to find someone of great integrity and knowledge of the resolution of disputes to make sure that the process produced by this mediation processing scheme was run fairly. I mean, it was an absolute bonus. He had substantial knowledge of criminal cases because he was able to review files where Post Office said this wasn't fit to mediate because this person was going to be prosecuted or had a criminal conviction. Sir Anthony went and reviewed the files, and in every case he said, that's not true, they can go through.
I want to look at a few of the meetings where the issue of whether or not to mediate came up. Could we start, please, with poll 26673? So this is, hopefully the date is on the first page. It's the 16th of June 2014. Could we go to page 3, please? Sorry, page 2. And if we can go down to have point 3 at the top of the document. This case M54 was discussed to inform a decision as to whether the working group should recommend the case for mediation. Second Sight had, in their final report, recommended mediation. It says the following points were considered during the course of the discussion. Regardless of a decision to recommend mediation by the working group, either party had the right to decline to mediate. Now, did you disagree with that?
No, I think mediation has to be a consensual process.
So, the extent to which cases raise issues that had not been previously explained to the satisfaction of the applicant in the context of the benefit of mediation for the applicant in terms of being able to move on after mediation from the events being mediated. What does that mean?
This is a particularly difficult case because it involves someone who'd suffered, I believe, criminal conviction. I may be misremembering the number, but I think this is one where there was a criminal conviction and there was strong opposition from Chris Ojard in particular that you could mediate anything post a criminal conviction. But the financial loss was still there, whether they were convicted of something criminal or not. And if their conviction was based on some misinterpretation or some plea bargain under false circumstances with limited disclosure, we all felt that they should still have the opportunity to go face to face and discuss the financial issues.
So was this a case where Second Sight had recommended mediation, the JFSA were in favour of mediation, but Post Office were against mediation?
Yes, because there'd been a plea bargain in this case, if I'm, again, interpreting the number correctly. And this individual had plea bargained to false accounting to avoid a theft charge and going to prison. But whether they'd actually done false accounting or not was pretty dubious.
If we go to the bottom of the page, it says, it being apparent that the matter of whether the working group should recommend M54 for mediation might proceed to a vote, the working group agreed the test the chair should consider, if called upon to use his casting vote as, on the assumption that both parties approach mediation in a genuine attempt to reconcile their differences, is it reasonably likely that the parties will reach an agreed resolution of their issues? And then over the page, it says the working group moved on to a vote, Post Office voted against, JFSA voted for, and the chair undertook to decide the matter and provide the working group with his reasoned written decision. So at this point, were the JFSA engaging in a position where the working group were going to determine whether or not to recommend a mediation in circumstances where Second Sight has recommended mediation?
Yes.
Why was that?
Because this is, I think, one of the first times this occurs, and it was somewhat of a curveball, because we'd previously understood the scheme. If mediation was recommended, it would go through. Post Office strongly objected and indicated they wouldn't take part in the mediation.
So is your evidence that this was being caught off guard, but you're engaging in the debate and the vote at the time?
Yes.
Could we look, please, to... Sorry. Poll 30266665. We've got a minute of the call on the 26th of June, which you see you're in attendance at. Please, can we go to page 12? Sorry, page 8. So we have M54, that's the case we were just discussing. And it said the chair asked all parties to consider the steps to be taken to inform, it should be their applicant, of the decision not to mediate the case. So it appears that Sir Anthony Hooper had decided against mediation, or recommending mediation in this case. Is that correct?
That's correct.
And because that you, Kay, I assume that's you,
Yeah.
Raised a concern about sharing the chair's decision. The chair noted the concern, and then it says AB, presumably that's Sir Alan,
It is.
voiced concern about the additional time delay this would cause the applicant, but agreed the working group should take time to consider how to proceed in this case. And then if we can scroll down, please. We see at the bottom AB again. AB queried the role of the working group in the recommendation to mediate when Second Sight had recommended mediation. It was noted that this was the previously agreed process and the one followed in M54. Do you recall the discussion that led to this minute?
Yes, this is the point at which we objected, really, to the intrusion of the working group committee into the recommendations by Second Sight. It was clearly going to cause delay and distress for the applicants when they had cleared the hurdle of proving there was a dispute that could be mediated.
when it was said, it was noted that this was the previously agreed process and the one followed for M54, at that stage, were you in agreement that M54 had followed a previously agreed process?
No, that's the point. Belinda Crowe has written this minute. The first half of the second sentence belongs with the first. AB queried the role of the working group in recommendation to mediate when second site had recommended mediation, which was noted this was the previous agreed process. Stop. This was different from the one followed for MO54.
I can come down, thank you. I don't propose to take you to minutes of other working group meetings, but I can if you like. They show, as you said earlier, that JFSA from then on would leave the room or not participate in discussions when the working group were deciding whether or not to recommend a case for mediation.
That's correct. I mean, the latter meetings were held at Matrix Chambers rather than Bond, Dickinson, Womble's offices. But we left the room and sometimes the building until they'd finished dealing with their interference in the scheme, because frankly it was a power the working group did not have, whatever Chris Ojard's explanation was when he joined Post Office.
And was it the case that Sir Anthony tried to encourage the JFSA to stay for that discussion?
He did, but I don't criticise him for that. He simply wanted a straightforward way forward for the claimants who were being caught up in this battle.
And could you explain the basis on which, or the reasons for, not participating in those discussions, other than you've given evidence that it wasn't the agreed process? Were there any further reasons for not participating in the discussion?
Not only was it not the agreed process, it was not what had been advertised to the claimants when they made an application to join the scheme. Once you've joined a scheme and the rules are set, you can't then do what Post Office often did, which is slip change into some other shape. So you do something different. You've got the people on board, so then suddenly they're not going to Clacton-on-Sea, they're off to Scarborough.
I want to move on, still in the time of the working group, but could we bring up your statement, please, at paragraph 91, which is page 24.
Is this the second 91?
You're quite right, yes, it's the second 91.
Apologies for that.
No, none needed. So it's the one, when it arrives on screen, it is meeting with Paul Reynolds. So if we could go to the yes, if we could go to the bottom of the page, please. So this refers to a meeting you had, I think it's a coincidental meeting where you bumped into Paul Reynolds at Bonn Airport in Germany on the 17th of September 2014.
Yeah. I was waiting for my flight by the gate and she hove into view with two other people from the Post Office.
You say in your statement, I will come to the email shortly, that you've now seen an extremely inaccurate file note of that conversation. When did you first see what you describe as the inaccurate file note?
In the papers for this inquiry.
Before seeing that file, or what you describe as the file note, would you have recollected this conversation with Paula Reynolds?
Yes, I remember meeting her at the airport and bearding her, if that's the correct phrase, with some sort of encouragement for her to settle and at least face up to the claimants and explain to them what had happened and pay them back their money.
Let's look at the note, actually. We'll go straight there. It's Paul, 2 zeros, 101367. So it's an email from Paula Venables to Chris Ojar. It's on the 17th of September. So this is made on the day of the meeting. Is that right?
It's the 17th of September is when I saw her at Bonn Airport.
Do you remember roughly what time the meeting was?
No, I can't. It was in the morning or around lunchtime, at a guess.
But you would accept that this is a contemporaneous account. I appreciate you dispute the accuracy of it, but it was made on the day of the meeting.
Well, it appears Miss Venables has sent an email on the same day, yes.
It says that it refers to just bumping into you at Bonn Airport, had a chat together off the record, but of course not really. Do you know what that it means, or what would lead to that impression?
Well, I did say that. I said, you know, Paula, can I have a word off the record? Because I do think you need to settle this, because the sub-postmasters need their money back, and they ought to have some sort of face-to-face explanation to explain why they've been treated so badly for so long. And if you don't settle this, you'll regret it.
It says, I'm not going to go through all of the document. I think it's the fourth bullet point down. Can we get Angela to lead on mediations, particularly if we think we are unlikely to move our position? Kay's view is she is credible, understandable, brackets, v important, close brackets, and stands the best chance of getting people on side, or at least to feel they have been listened to, even if they still disagree. Now, take it in stages. Is Angela in that bullet point referring to Angela van den Bogart?
Definitely Angela van den Bogart.
Did you discuss Angela van den Bogart in your meeting with Paula Venables?
Yes, we did, because she was getting to the bottom of an investigation which seemed to have been carried out for the first time on any of the applicants' cases, and we're actually finding out why the differences had occurred. So she was very thorough, easy to understand in her explanations of how differences arose, and if you cut her in half, she'd be post office through and through.
Did you say that if she about being post office through and through?
No, I did not say that to Paula Venables.
So the point that Kay's view is she is credible, understandable, is that a fair comment for Paula Venables to have made?
Concerning the investigation of differences in the network, yes, but not generally.
So we should consider being more open to mediation on the cases where more money was at stake, not less, because this had a greater emotional impact on those affected, brackets, lost jobs, homes, etc., close brackets, and therefore they are the ones who need to vent more and who would benefit from us allowing them to yell at us. She thinks we're big enough to take that.
Where on earth has that come from?
So, what is, do you? That was about to be my question. From what was said at the meet, or do you recall anything being said at the meeting that would lead to this note being made?
No.
We then have. It says Joe Harrison brackets JA-SPMR. Now that's presumably means Joe Hamilton, James Arbuthnot, sub-postmaster.
Yes, I'm pretty certain it's Hamilton, not Harrison.
Kay intends to go into mediation with her. She thinks she needs looking after. Kay indicated that Joe had done something wrong but feels sorry for her. Now I'm going to pause there because I know you dispute that. What is your recollection of what was said about Joe Hamilton at this meeting?
My recollection is I said the system was such that Joe had been muddled and concerned, very upset, and had had to roll over a difference, which Angela had said when we discussed MO35, that was a reason she couldn't get to the bottom of the reasons for the difference, because it had been rolled forward over so many periods. I didn't feel sorry for Joe. I did say she might have got out of her depth with the system, but she didn't have any documentation to check, which isn't in the note. And I thought they could have been more sympathetic than taking someone into her home and interviewing her without anyone else present and attempting to take her goods, which was prevented by her mother. I don't remember saying Joe had evidence that they hadn't got at the time of prosecution. I probably did say Joe should have had information disclosed by post office that wasn't available at the time of prosecution. This is a complete misrepresentation of what I said.
Would you have said, as part of the discussion generally about the fact of a guilty plea, whether or not you agreed with that guilty plea, would you have mentioned that?
No, I don't believe we discussed prosecutions or guilty pleas as far as I recall. My notes of this conversation have not been reduced to a file note at the time. They were in passing at an airport.
Thank you. That document can come down. I want to go back to one of the 2 points you raised, one of them I said I'd come back to. It's page 28 of your statement, please, paragraph 107. And if you could go to the bottom, please. Thank you. So these are the two of the concerns that you raised here. We looked at 108 earlier. 107 is the question, where has the sub-postmaster's money gone? And you say that Sir Anthony Hooper asked that question regularly.
Yes, he did. Now, you say that Post Office, at the end of that paragraph, Post Office failed to provide any explanation or figures at all. That's in relation to where's the money gone. Chris Ojar said he would get this information on several occasions, but he never did. I just want to look at a few of the meetings on this issue, and could we start, please, with Poll 30-26685. So this is a meeting on the 16th of September 2014. And we see you're in attendance. Could we look at page 6, please? And if we go down to have suspense account paper, sure, thank you. So suspense account paper. Now, you do say in your witness statement that there are at least 2 types of suspense account potentially relevant. What type of suspense account was being discussed here? We should be discussing what I would call the head office suspense account, where differences were posted in the main Post Office Limited accounting system. And I would expect it to include things like the differences on reconciling Camelot or Bank of Ireland controls accounts. But it must be that place where the sub-postmaster's money had gone. And I know, talking to Ron and Ian at the working group, they definitely volunteered many times to go to Chesterfield or wherever the accounts were held and have a look for themselves to actually ascertain what had happened to the money. Chris Ojard, on many occasions, confirmed that wasn't necessary, it was too complicated, they weren't going to be paid for it, and he would produce a paper from his accounts team asking the CFA. I've no idea what this paper was, but I don't believe it was a substantial explanation. So, but this part here where the Post Office explained they provided with a paper, you say you don't know what that was? No, I've never seen it. Post Office explained that the request was too broad
and they could not see how it linked to any case at Second Sight, which we were investigating. Second Sight undertook to provide their further specific questions in writing to Post Office. Could we look at the meeting on the 17th of October, which is Poll 3040475? So the 18th of October, as I say, could we go to page 2, please? And this is referring back to the minutes of the 16th of September meeting. So referring to page 6, item 5, Second Sight has written to Post Office with questions on the suspense account, but are yet to receive a response. The Chair noted the complexity of the questions. He asked if there was a surplus in the account, would it be taken into Post Office income? Post Office confirmed that it would after 3 years. Post Office and Second Sight agreed to clarify Second Sight's precise needs for information. So the Chair asked Post Office for figures taken into income from the suspense account to be broken down year by year. Now, firstly, do you recall this conversation beyond what's recorded in the minutes?
I remember a November 2014 minute where Chris Ojard gave a specific undertaking. I can't remember the wording, and that information was never followed up. But I know from my own investigations that there were amounts of over £1 million taken to the Post Office profit and loss account over a 5-year period.
I think you've answered the question I was about to ask on what came next. I'm going to jump forward to the 14th of January, please. Poll 3043633. And we see 14th of January 2015. Could we go, please, to page 3? And to the bottom of the page. Thank you. So it's additional agenda item, update on Part 2 report. So that's the Second Sight Part 2 report.
Yes.
And the Chair asked for an update on progress of various matters. And at the bottom we see the Chair asked if Post Office was able to answer the question on suspense accounts that had been posed for several months. Ian reported that the information had not yet been provided. The Chair asked that this be addressed as a matter of urgency and suggested that Post Office arrange a meeting between Second Sight and Post Office finance staff to do so. Now, the inquiry has heard evidence and there's documentary evidence on matters that happened thereafter. My question to you on this is, were you involved at all in this investigation into suspense accounts?
No, I was not.
Did Ron Warmington or Ian Henderson tell you anything following this meeting about that investigation?
In about 2015, I brought the paper to remind me, I was told by Ian Henderson the amounts credited to the profit and loss account of Post Office in 2010-11 was £612,000. In 2011-12 was £207,000. In 2012-13 was £234,000. And in 2013-14 was £104,000.
Okay, as you're reading from a document, is that a note of a conversation?
It's a note of a conversation I had with him. I've highlighted it in yellow so I could find it.
But it's gone off my. That was Ian Henderson who told you that.
That's correct.
Did you have any further involvement in investigating suspense accounts?
There was no opportunity because the mediation working scheme was cancelled unilaterally by Post Office without that question ever being answered.
I want to now turn, that document can come down, thank you, to my final topic, and it's what happened thereafter, and the group litigation. Oh, sorry, sir.
No, before you do, am I right in thinking that either Mr. Henderson or Mr. Warmington had in their witness statement, when they gave evidence, figures either identical to or very similar to the ones which Ms. Linnell has just referred to?
So off the top of my head, I couldn't say with confidence, but I, at the break, we'll double check that point.
Okay, I don't think I'm imagining that, that's all.
If it assists, they're in the published accounts.
Right, so there's a public record of them somewhere, anyway. Yes. Yeah, fine. Well, you needn't go researching then, Mr. Stephen.
It shows a confidence in my memory. Turning then to the litigation, please. I asked earlier about the prospect of litigation in 2012, and my understanding of your answer was that you need funding for litigation.
Yes.
And in order to get funding, you needed to have sufficient information to show a basis to put forward your claim.
Yeah, and a reasonable chance of success, or no sensible lawyer would take it on.
I know I'm going to ask you some questions about the process of litigation, but remember, I'm not asking you anything which would require you to provide privileged information unless you were in a position to waive it and you wanted to waive it.
Thank you.
Once the mediation scheme had finished, so in 2015...
It was abruptly ended by post office in 2015, and I had a letter from Jane McLeod out of the blue.
How easy or difficult was it for you to find legal representation for the group litigation?
Sir Alan and I did several things at the end of the mediation scheme. First of all, we had a look at the evidence that had been produced by the Post Office and Angela van den Bogart. We also, without wishing to pierce privilege of mediation discussions, had some general feedback from those people who had been fortunate enough to reach the mediation panel. And thirdly, we started putting together a panel of potential lawyers who had experience in group litigation. We then went to several firms of lawyers, and as happenstance would have it, we ended up with Freeth, who also introduced us to litigation funders, after the event insurers, and counsel, Henderson Chambers.
And it's well known that the litigation was funded by a litigation-funded Ethereum.
Ethereum were the funders, yes.
If you hadn't had a funding by way of a funder such as Ethereum, would the GLO claimants have been able to pursue the litigation? No,
they wouldn't. And if they hadn't had generous solicitors and counsel prepared to take a proportion on a conditional fee success arrangement, we wouldn't have been able to process either. And the funders recognised the importance of having after the event insurers for people in our claimant's position. So we had to put all those four pieces in place before proceeding to litigation.
Just for the benefit of the public, when you say after the event insurer, do you mean an insurer who would indemnify the claimants if the litigation was unsuccessful and a cost order was made against them?
If you look at the case of Lee Castleton, it's very clear. If you lose in a court and the court has the power to award costs against you, it can have severe financial implications. The purpose of after the event insurance is to put an insurance policy in place, so if you lose, the insurance policy coughs up and pays the costs.
So, as I understand it, you say these sort of essential ingredients were A, Ethereum or a litigation funder, B, the after the event insurer, and C, solicitors and barristers who were prepared to take a portion of their fees on a conditional fee basis or a no-win, no-fee basis?
Yes, bearing in mind all are essential, so you could take them all as one. There's no priority in that listing. And to get the solicitors and barristers interested, you have to have sufficient evidence to prove that something's been done wrong, and there is similarity across a group of claimants so that there are sufficient to actually put a force together to form a group litigation group. Quite high hurdles to overcome.
And the just rounding this off, the information that you were able to obtain and put forward to the solicitors and barristers to get them interested, did that come from the mediation scheme?
Yes, one of the things about going into the mediation scheme, because normally anything discovered in mediation is privileged and within the bubble of mediation. But one of the things JFSA managed to negotiate is any document disclosed in the mediation would be usable by the claimant person. So yes, that's where the data came from to enable litigation to take place.
Before I ask another question about the GLO then, to what extent, if at all, do you think the mediation scheme fulfilled its purpose?
At least 85 or 90%. Without the mediation scheme, there wouldn't have been the volume and capacity of claimants to go forward, because Post Office has, throughout my involvement with them, deliberately or otherwise withheld documents that are essential for the defence of individuals or the prosecution of a claim.
Can we look at page 31 of your statement?
So again, Mr. Stevens, sorry, but if it be the case that the Post Office was seeking to use the mediation scheme as a sham, to use that word, in fact, on your view of it, it had the opposite effect because it provided you with the ammunition for the litigation that followed.
Yes, that's exactly right.
Fine, okay.
Paragraph 119 and 120, you say that the Freeth legal team put in place all the necessary mechanisms and steps to cope with and respond to the aggressive Post Office litigation strategy, which in my view and the view of others was primarily designed to run the group litigation claimants out of funding. Mr. Justice Fraser refers to this in his judgment by implication. And you go on to specify what you saw as the aggressive litigation tactics by saying they included limited and sporadic late disclosure, contested cost applications and other litigation tricks such as Post Office's recusal application to derail the planned 5-trial litigation. I want to just focus on one aspect of that, and that's the recusal application. Can you describe, were you in court when the recusal application was announced?
Yes, I was.
And what was your reaction to that?
It happened after lunch in the middle of someone's testimony. And I think Mr. Degar Robinson stood up and made the application. Fraser J insisted the witness was completed before he dealt with it, which was kind, because otherwise the witness would have been held over indefinitely. And I think it was an absolutely shocking result, because it was the tactics of a desperate drowning man, as far as I could see. To recuse a judge who had been no more than colourful in his language and comparatives. It was the handing down of the first judgment that same morning. And there were phrases in it which clearly the Post Office and their legal team objected to, such as the Flat Earth Society and things like that. And I think it was absolutely disgraceful because there was no bias that I could see in that judgment. However, I'm not a lawyer, I'm a mere accountant. But I thought it was a disgraceful tactic and designed to stop the trial on the Horizon system, add huge legal costs to our side, and try and derail the whole process.
Did you speak to other people in the claimant group about the fact of the recusal application being made?
I certainly did, because people wanted to understand what it was.
And can you summarise what the general feeling was within the claimant group about the application having been made?
I can only say this from my personal point of view. I think there was some anger and frustration as yet another tactic by Post Office stopped the move slowly towards redress, justice and some sort of conclusion as to what had happened to them.
The final question, or possibly questions I ask, is about interaction with government. Now, when Sir Alan gave evidence, Mr Beer presented a series of letters that he had sent to ministers and went through various meetings. Did you have any interactions with government or government ministers in respect of the Horizon IT system?
Sir Alan and I decided that he should write the letters. We discussed the contents before they were sent. In particular, I was a part of his issuing of a bill to, I think, the Prime Minister at the time, Boris Johnson, concerning the litigation costs of 46 million plus interest.
Thank you. So before I say, so I shouldn't, famous last words saying that's my last question. If I may just have a moment to check a note. Thank you. So I do actually have one further question, and it's going right back to the start of your evidence when you referred to working for a firm called BDO.
Yes.
We've heard evidence about Lee Castleton's civil case and an expert report being produced to Womblebon Dickinson, not disclosed in the hearing, by BDO, or sorry, BVO Stoy Haywen. Did you have any involvement in the Lee Castleton case at all?
No, I really wasn't aware of Lee Castleton's case till I met Alan Bates and we went into this process.
I'm not suggesting it's necessarily the same firm.
It will be the same firm.
Will be the same.
Because Stoy Haywood and BDO, which was formerly BDO Binder Hamlin, amalgamated at some point, but I wasn't involved in such high echelons of the firm to know anything about that.
Thank you, sir. Those are the questions I have. Now, Ms Linnell is represented by Mr Steen, and would like to ask questions in re-examination under Rule 10.2, which, subject to your approval, I think is open to them. I think if we are doing that, though, first, I will check if there are other co-participants who wish to ask questions. No, sir. So I think Mr Steen has 2 questions.
Literally 2, Mr. Steen.
2 topics, sir.
Sorry.
Well, no, I'm just concerned about the shorthand writer, that's all. If you're going to be literally a few minutes, I'm sure she'd prefer to finish, but if it's more than that, we'll ask her which she'd prefer.
Our shorthand writer is confirming that if it's a few minutes, then to go ahead, and it will be, sir.
Thanks.
So the reference in Mr Warmington's statement to the suspense account monies is his statement, WITN 01050-200, page 7, paragraph 12, and the figure of £612,000 is given. And you'll recall I asked him questions about that matter, and he referred to other sums.
Yeah.
Ms Linnell, just 2 topics, as I mentioned to Sir Wynne. You were asked a question by Mr Stevens about your first joining meetings of the JFSA. And we all know from the ITV drama that the meetings were sometimes at village halls, Penny Compton famously, otherwise at Fyneton on occasions. Now, regarding funding, which was what you were asked by Mr Stevens, how broke were the sub-postmasters that you met at these meetings?
Very broken in minus red land, as my friend used to call it, with lots of credit card and other debts hanging around them.
Now, sometimes in relation to your support of sub-postmaster mistresses working with Mrs. Jeremiah, you were helping them try and make their way through the mess that'd been made of their finances. That needed on occasions to get things like bank statements, which aren't necessarily free. How did you manage to do that?
Barbara and I paid for them.
Another question that was asked by Mr. Stevens was regarding the JFSA and whether it engaged with the National Federation of Sub-Postmasters. Was there any desire amongst the people that you met at the JFSA to engage with the NFSP?
The feeling among people I spoke to who are SPMs is that the National Federation of Sub-Postmasters were no more than part of Post Office and not to be trusted.
So thank you.
Well, first of all, should I be calling you Dr. Linnell?
You could, sir.
Well, I just, hidden amongst your witness statement was a reference to you becoming a doctor in 2024. So, Dr. Linnell, thank you very much for your witness statement, and thank you very much for giving evidence before me this afternoon.
Thank you, sir.
Thank you, sir. And I'll apologise for repeatedly saying Ms. Linnell all the way through.
No, I'm happy.
I just like everybody to know that I do read the lines of the witness statement. That's all. Thank you very much, everyone. And 9:45 tomorrow, yeah?
Yes, sir. Thank you.